Good morning. On June 24th of 2009, Appleton Parkersburg High School football coach, Ed Thomas, left his wife, Jan, and went to work. He went to work at the weight room that was a makeshift weight room that was on the campus of the soon-to-be the new Appleton Parkersburg High School. He left his wife to go and work with his football team, a team that he was preparing for the upcoming season. There were 2 shifts that morning of lifting for his players and for other athletes at the high school. There was one at 6 a.m. and one at 7 a.m. Little did Ed Thomas know that at 7:45 in the morning, approximately, the defendant, Mark Becker, would walk into the weight room, walk across the weight room, pull a .22 caliber 9-shot revolver and empty it into Ed Thomas. Ed Thomas, on June 24th of 2009, was gunned down by Mark Becker. He was gunned down in front of over 20 Appleton Parkersburg High School students in the weight room that morning. Mark Becker, on June 24th of 2009, made a choice. Mark Becker chose to take a gun and to go and shoot Ed Thomas at the weight room. He made this choice consciously and with full understanding and appreciation of the consequences of his acts. Now, on June 23rd of 2009, Mark Becker had gone to his parents' house. His parents are Dave and Joan Becker, and they live on an acreage north of Parkersburg. He had gone there to stay with them for the evening and got up relatively early on June 24th of 2009. He got up to drink coffee with his parents, with Dave and Joan Becker, who were on their way to work early that morning. And Mark Becker told the police that when he woke up on June 24th of 2009, he made the choice to kill Ed Thomas that day. Mark Becker then had coffee with his parents. His parents went to work. They left him at his house. There was no one else there. He was the only one. His brother, Scott, had gone to work out and to work that morning, had been at the weight room early. And Mark Becker made plans to murder Ed Thomas. He wanted to make sure his parents were gone. He then went down into the basement of their home, where he put on a pair of gray coveralls. He then broke into the gun cabinet was in the basement. There is you'll see a photo of it, of the gun cabinet, that there was a pair of antlers that were on the counter near the gun cabinet, and he used those pair of antlers to pry off the handle to the gun cabinet. In that gun cabinet was the .22 revolver. Mark Becker chose the gun out of the gun cabinet. You'll see a photo of it later on in this case, Not only is there a .22 caliber revolver that was in there, there are also a lot of other long guns that are there. The Beckers are a hunting family, apparently. Nothing wrong with that, but there were other guns there. So he chose the gun that he was going to use. He then loaded the gun. He found some .22 rounds of ammunition that were in the basement. He loaded the gun, and then he went out for a little practice shooting. You will find in the pictures that you'll see from the Becker home that there is a birdhouse that is outside of their front door. Mark Becker then took the gun and stood near the doorway and took a couple shots at the birdhouse. He was practicing. He missed the birdhouse. He then told the police, you'll find in the evidence, that he then knew he was going to have to get pretty close to Ed in order to kill him. So then he chose to go back in the house. He then chose to get in his car, and he chose to drive to find Ed Thomas. Now, what's going on in the meantime? We'll pick this up with Mark Becker. But at the weight room, what's going on while Mark Becker is starting to look for Ed Thomas? Well, there's kids that are at this weight room. There's people that you'll hear from, people like Brandon Simpkins and Robert Jansen and Matt Wicks and Michael Abbott and Damian Menon and Josh Schwark and James Martinsdale. These boys, 15 years old, most of them, are at this weight room lifting weights. It was test out day at the weight room. That's what Robert Jansen will tell you. You know, they're trying to get max weights. They're working, they're getting ready. All these kids had gotten up early to go work out that morning to get ready for the football season. And that's what they were doing at the weight room while Mark Becker searched for their coach. They went to this weight room here in Exhibit 4 and Exhibit 5. This is the weight room at Appleton Parkersburg High School, the one that was used at the time. And Exhibit 6 also gives you another vantage point of it on the side. That's what was going on while Mark Becker began his search for Ed Thomas. So, we pick up with Mark Becker, who went to Appleton, went to the city of Appleton to search for Coach Thomas. He went, drove in his Lumina, a Chevy Lumina that he had, in his gray coveralls. By the way, one thing that you'll learn from the evidence in this case is that Mark Becker had loaded the gun, fully loaded the gun, and had it on the seat next to him as he drove to Appleton, and thought that he might need to move that gun off the seat in case the police would happen to see him or stop him. So he hides it in the map pocket of his car. He then goes to Appleton, like I said. That's what the evidence will be in this case. And he goes to the home of a woman by the name of Janice Stahl. Janice will testify in this case. And in the morning, Mark Becker came up to her house, and she'll tell you about that. But Mark Becker's in these coveralls. It's in June of 2009. And he walks up to her house and asks her about Ed. Ask her about Ed Thomas. Does she know where Ed Thomas is? Well, Ed Thomas has never lived in the home that Janice Stahl had, and said that she didn't know. She didn't know anything about Ed. And Mark Becker says, okay, and he leaves. Continues on his search for Ed Thomas. Thought that he lived in Appleton, Iowa. That's what Mark Becker thought. On his after he leaves Janice Stahl's house, he runs into a man by the name of Brian Boozman. Brian Boozman is a junior high assistant or associate principal in Applington. And Brian was out for a run, and he's kind of running down the middle of the road. And as he's running down the middle of the road, his buddy, who apparently doesn't like to run, is following him in a pickup truck. And coming opposite them is Mark Becker, somebody who Brian Boozman had known some time ago. And Mark Becker stops Brian Boozman and asks him, "Where can I find Ed Thomas? Where is he?" And Brian's like, "Well, I think he's teaching driver's ed, or he's over at the high school at the weight room," something to that effect. And it comes up in their short conversation as to why Mark Becker would be looking for him. And he tells Brian Boozman he wants to talk to him about the Tornado Relief Fund, which the evidence will show is absolutely not true. A deception by Mark Becker. He then leaves Brian Boozman and he goes over to Parkersburg. He drives the short distance of about 5 miles and he goes to the elementary school. He does not go directly to the weight room. He goes to the elementary school. He gets out of his car. You will learn from his own mouth, whenever he talked to the police, that he had the gun on him in his coveralls whenever he went into the elementary school. He runs into a person by the name of Susan Myers. Susan is a custodian, and she and the head custodian, Craig Kalkorff, who you'll also hear from, were working on their punch-out list for the summer. Getting floors done, getting repairs made, things of that nature. And Mark Becker walks into one of the rear doors of the elementary school into the kitchen area where Susan is, and he asks where Coach Thomas is, where Ed Thomas is. He asks where he could find him, or asks Susan where he could find him. And Susan doesn't really know. She says, "You need to talk to Craig." All right? So that's what Mark Becker does. But before he does that, what the evidence will show in this case is that he goes back out to his car that was parked on the street. He removes the gun from his coveralls and puts it back into the car so Craig won't see it. He then goes back into the elementary school, talks to Craig Kalkorff, who will tell you that he had a normal conversation with this man. He was looking for Mr. Thomas, is what Craig will tell you. And Craig will tell you that, okay, Mark's going to work for Ed Thomas. We had volunteers that would come a lot whenever the tornado had occurred to help with all of that pickup and cleanup and things. So he thought it was something normal, nothing out of the ordinary with Craig Kalkorff. Craig directs Mark Becker to where Coach Thomas is at. He tells him, of course Craig Kalkorff has no idea what's about to happen. And he tells Mark Becker to go to the weight room to find him. So he has to drive down the hill to the weight room. What happens in the weight room is horrific. Mark Becker gets out of his car, again, does not take his gun. What he does, and there'll be evidence of this, of the kids that were in there that saw it. He poked his head in the door. Coach Thomas, if we get Exhibit 11. Go to Exhibit 11. Okay. He poked his head in this door. This is the same door in the diagram right here. He parked his car here right by the door, pokes his head in the door, and he leaves. There are a couple of students that saw him poke his head in the door. Pokes his head in the door. Then he goes back to his car and gets his piece. That's what he likes to call it in the interview. Gets his piece Well, at the time that he poked his head in the door, what the evidence will show is that Ed Thomas was standing here near where the blood area is, near a makeshift room that had a washer and dryer in it. So Mark Becker poked his head in, sized up his target, goes back and gets his gun, walks in this door, walks straight across. We get the next exhibits up. Walks in this door. This is where the weight room is at. Coach Thomas is over here. That's what the evidence will be. He walks across the weight room. He pulls the gun out, and he guns him down in front of all those kids. He shot him. He emptied the gun. 5 bullets, 5 times. Shot him in the head, right here. Shot him here in his face. Coach Thomas had put his hand up like this, and a bullet passed through his hand. And there's a grazing wound that's on his chin. He also shot him here. And then he shot him once in the knee. And then as he's down, he kicks him. Kicks him in the head, kicks him in the chest. And I'm going to quote something that you will hear from a couple of these boys that will come in and testify. He kicks him and he says, "Fuck you, old man." That's what the evidence will be in this case. He then, before he did that, as he is standing here, Brandon Simpkins is this far from his coach. And as Mark Becker walks in, he points the gun at Brandon Simpkins' head. Brandon Simpkins thought he was dead. It was a total shock to everybody. He closes his eyes and he hears the shots. All of these kids will tell you they thought it was a fake. They thought it was a put-on. After Mark Becker does that and stomps on Ed Thomas, says those things about him, swears at him, he then walks out the back door of the weight room. He walks around and he gets in his car and he takes off and he leaves. Daniel Smith, who is another witness that was outside, is an adult who you'll hear from about seeing Mark Becker leave. The kids are flooding out of this place. A couple of them go over to a neighbor's house, not a witness that we'll call. His name is Schneiderman. He was across the street. He came over, and as he's coming over, Dan Smith is standing there, and Mark Becker is leaving this. He backs out, and he goes back, and he goes north on Johnson Street. As he's doing that, Dan Smith points. Schneiderman runs after him, is what Dan Smith will tell you. And as he does that, Mark Becker hits the gas and he's gone. So where does he go? Where does he go? He goes back to his house. Now, of course, you can imagine, 911 calls are coming in. It's chaos. Okay, nobody expects this to happen. It's chaotic. And as the police are coming, Jason Johnson, the sheriff, Chris Lurie, by the way, Parkersburg police chief, responds pretty much directly to the weight room. He's a witness here. And Jason Johnson, the Butler County sheriff, responds as well. He's gets called, he gets in his car, and he and a couple of his deputies are, running as fast as they can to Appleton Parkersburg High School. If Jason Johnson gets partway down, they get a suspect description. And it runs through Jason's head concerning Mark Becker, and he turns on C-51, which is a county road that runs right by the Becker property. And as Jason Johnson turns into the Becker property, turns onto the lane, guess who's behind him? Mark Becker. Jason is by himself. The sheriff is by himself. He pulls his car ahead. He gets across the hood of his car, and as Mark Becker is driving up the lane, he has the gun that he just used to murder Coach Thomas with hanging out the window. He walks or drives up and drops the gun. Mark Becker will tell you in his interview he's going to turn himself in, that he knew he was caught. And that's exactly the way he was acting with Jason Johnson. So he drove it, drops the gun, he gets out, Jason Johnson cuffs him. As he's cuffing him, Mark Becker makes a couple of statements to him. He tells him, as Jason gets the cuffs on him, Mark is prone on the ground. He's got blood on him from where he kicked Coach Thomas. He's prone on the ground, and he says, "Ed is done, and I am done with Ed." He also says, "I stopped him for you cops." He says that a couple of times as well. He refers to Ed as Ed, and he calls him him, calls him a person. He then is arrested. He's taken down to the sheriff's office where he's interviewed by Agent Chris Calloway. DCI has now gotten involved in the investigation and has brought all of this together. And Chris Calloway interviewed Mark Becker for a little over an hour at the Butler County Sheriff's Office, and you'll hear that audio interview whenever Chris Calloway testifies in this case. Now, looking at all of this evidence, what will it ultimately show you in this case? Well, what it will show you when you look at all the evidence in the case is that Mark Becker was angry, extremely angry with Ed Thomas. He had perceived that Ed was harassing him and that he had wronged him in some way. The evidence will be, at least in part in this case, that the reason that Mark Becker killed Ed Thomas was wrapped up in his mental illness, part of it. But that is a far cry from Mark Becker being insane. No one in this case, not myself, not Mr. Prosser, or anyone, will dispute the fact that Mark Becker had a mental illness. We won't dispute that. But the evidence will be in this case, and if I say it once, I'll say it 1,000 times. Mental illness does not equal insanity. Let me say it again. Mental illness does not equal insanity. It does not. The bottom line in this case is that Mark Becker killed Ed Thomas because he was angry with him, and the most expeditious way for him to deal with that on June 24th of 2009 was to choose to take a gun and to take care of his problem. That's what Mark Becker chose to do. The evidence will be that he had plenty of time to think. The evidence will be that he had plenty of time to make his choices. Mark Becker's choice, his choice on June 24th of 2009 wasn't to call his parents, wasn't to get his medication, wasn't to take himself to the hospital, wasn't to go see Jason Johnson, wasn't to do any of those things. Mark Becker's choice on June 24th of 2009 was to take a gun and to murder Ed Thomas. Instead of doing all those other things, Mark Becker made the calculated choice to murder Ed Thomas. At the end of this case, the judge will give you an instruction that will tell you that your job as jurors, your job is to find the truth and to do justice. That's your job as jurors. And what we are asking for from you in this case, as you listen to this evidence, whenever you make your decision, is that you enter a verdict that is just and true. And that verdict in this case is that Mark Becker is guilty of murder in the first degree. Thank you.
Ladies and gentlemen, good morning. We're here today to answer the question, why? Why did Ed Thomas die? The evidence in this case is going to show that Ed Thomas died because on the morning of June 24, 2009, Mark Becker was insane. The evidence will show that Mark suffered from, and still suffers, from a mental illness called schizophrenia, paranoid type. And beyond simply having a mental illness, that mental illness prevented him on the morning of June 24th from knowing the nature and quality of his actions, and also prevented him from being able to distinguish between right and wrong in relation to that act. You're going to hear a lot of evidence in this case about Mark's mental health and his mental health history. Mark has struggled with mental illness for several years. The evidence will show that starting in 2007, Mark reported to his doctors that he was hearing voices. Also in that year, he began receiving medication for depression. In September 2008, Mark received his first diagnosis, for schizophrenia. You're going to hear testimony from doctors in this case who will explain to you what schizophrenia is, and they'll explain to you how Mark's illness caused him to experience delusions. You're also going to hear testimony about Mark's hospitalizations. Mark has been hospitalized on several occasions for his mental health issues, including twice at the end of November, or at the end of 2008. You're going to hear evidence about how at the end of November of 2008, Mark was discharged from the hospital for the second time, and he began receiving help from a social services agency called Cedar Valley Community Social Services. Mark's caseworker is going to testify about how, with his agency's help, Mark was able to get his own apartment and to get a job as a dough maker at a restaurant in Cedar Falls. But the evidence is also going to show that as a result of Mark's mental illness, he continued to experience delusions. On June 20, 2009, 4 days before Coach Thomas's death, Mark drove to a house in Cedar Falls. And the evidence will show that Mark went there to confront the homeowner because he was convinced and believed that the homeowner had been hypnotizing him since he was a child. Mark damaged the man's home and then led law enforcement agencies on a high-speed chase from Cedar Falls all the way up to Butler County. You're going to hear about the bizarre statements that Mark made to the police at the end of that chase, and you're going to see the video of police officers' efforts to try to interview him at the Butler County Sheriff's Office, where he again makes bizarre statements. Following that chase, Mark was hospitalized from June 21st to June 23rd, the day before Coach Thomas's death. And the evidence is going to show that Mark was discharged from the hospital on the evening of the 23rd, but he was not able to fill his prescriptions for psychiatric medication. Mark then spent the night at his parents' farmhouse between Allison and Parkersburg, and the evidence will show that during the course of that evening, Mark experienced delusions about Ed Thomas. Mark believed that Coach Thomas was literally Satan. He believed that night that Coach Thomas was trying to suffocate him. And in the early morning hours of September 24th, Mark decided he had to do something to make it stop. Mark was arrested in his parents' driveway shortly after the shooting on June 24th. You're going to hear testimony from the officers who arrested him and who spoke with him in the driveway, and you're going to hear about the bizarre statements Mark made at that time, including telling the police officers that he stomped Ed Thomas for them. Mark was transported to the Butler County Sheriff's Office, and you're going to hear testimony about the bizarre statements Mark made on his way there. Once Mark got to the sheriff's office, he was placed in a booking room, and he was alone for a while. And you're going to see video, not just the audio, we'll also show you the video of what happened once Mark got into that booking room. You're going to see him alone and making statements that are just bizarre. Then you're going to see Agent Calloway from the Iowa Division of Criminal Investigation come on and interview Mark later in that same video, and we're going to show you the whole thing. And you're going to hear Mark's statements to Agent Calloway where he describes what happened. He's going to describe the delusions he was experiencing that morning. You're going to hear him tell Agent Calloway that the shooting of Ed Thomas was an act of God. You're going to hear him tell Agent Calloway that Coach Thomas was what Mark called a devil tyrant. You're going to hear evidence that'll show that Mark, on that morning, believed that Coach Thomas turned people, including Mark, into fish, into animals, and into dead people. You're going to see Mark describe how he sees Satan in the interview room with him and with Agent Calloway. You're going to see him describe to Agent Calloway how he sees the agent being held by light and angels. You're going to hear him tell Agent Calloway that he sees Agent Calloway glowing and that he can see it in his eyes. And you're also going to hear Mark tell Agent Calloway that voices told him that he should take out Coach Thomas because Coach Thomas was being, quote, Lucifer. After that interview, and in the coming weeks, Mark was interviewed by a number of doctors. And you're going to see testimony, or those doctors are going to testify for you. And they're going to testify about their interviews with Mark, and they're going to testify about tests that were run on Mark, including tests to determine if he was faking schizophrenia. These doctors are going to testify that Mark did suffer from schizophrenia on June 24th, and they're going to tell you that beyond that, as a result of his schizophrenia, Mark was suffering from such a diseased and deranged mind that he was unable to know the nature and quality of his acts, and he was unable to distinguish between right and wrong in relation to those acts. These doctors will testify that on the morning of December 24th, Mark Becker was insane. I want to thank you for your time and attention. The state gets to put on its case before the defense calls its first witness, so we do ask you to please keep an open mind and reserve judgment until you have heard all of the evidence. Once all the evidence has been presented, we will ask that you return a verdict of not guilty by reason of insanity. Thank you.
Ladies and gentlemen, as you know, there are now 14 of you. Mr. Peters has been excused because of medical conditions this morning. This is the time for closing arguments. As I mentioned to you before, closing arguments do not constitute evidence. It's the opportunity for counsel for the parties to interpret and summarize the evidence for you and to argue to you all reasonable inferences and conclusions that may be drawn in their opinions from the evidence. We'll start with the state's closing. Mr. Brown, sir.
Thank you, Judge. Good morning. On June 24th of 2009, Mark Becker made a choice. On June 24th of 2009, Mark Becker made the choice to murder Ed Thomas. His choices that he made on the morning of June 24th of 2009 were calculated, they were planned, they were practiced, they were executed, and they were later explained by Mark Becker himself. On June 24th of 2009, Ed Thomas went to work. He was a coach at Appleton Parkersburg High School. He went to the weight room to get his team ready for the upcoming season. And not only did he help his own players, as they testified to in this case, he was there to help all the students. He planned their weight routines, he was there with them, and on June 24th of 2009, he was met by this man, Mark Becker, who came in with this gun. And he pointed this gun at Ed Thomas. And he pumped 6 to 7 rounds into him. Ed Thomas, on June 24th of 2009, was gunned down in cold blood. he was murdered. All as a result of the choices of Mark Becker. Now, what is it that the state of Iowa has to prove in this case? What do we have to prove? Well, there are 4 elements to murder in the first degree. The facts in this case, simply put, with regard to the elements of murder in the first degree, are overwhelming. I want to talk to you about the facts that support the elements of murder in the first degree. So what's the first element of murder in the first degree? And it's this one. That on or about the 24th day of June 2009, the defendant shot Ed Thomas with a gun. It's what is called the ID element, what I call the ID element. It's that this man here is the one who shot Ed Thomas. That's element number 1. Element number 2 is that Ed Thomas died as a result of being shot. This element relates to a lot of the testimony that came in through the medical examiner, Dr. Jerry McLemore. He died as a result of the gunshot wounds. That's element number 2. Element number 3 and element number 4 are really state of mind elements that we are required to prove beyond a reasonable doubt. The third element, which is one of the state of mind elements, is that the defendant acted with malice aforethought. We're required to prove this element beyond a reasonable doubt. And then the last element is that the defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Ed Thomas. Those are the 4 elements. We are required to prove the 4 elements of murder in the first degree and nothing more. This is what the law requires of us, the state of Iowa, the prosecutors in this case. The first two elements of murder in the first degree, there's no question here that it was Mark Becker. And there's no question that Ed Thomas died as a result of being shot. We could go through all of that evidence, but you already know what that is. And that's really not a fighting issue in this case. It really isn't. So the first 2 elements of murder in the first degree have been proven beyond a reasonable doubt. What about the other 2 that go to the defendant's state of mind? We'll talk a little bit about those. The first one is malice aforethought. And the court's instructions will be what is up here on the screen. But malice aforethought is a fixed purpose or design to do some physical harm to another that exists sometime before the act is committed. Malice is a state of mind, like I just said. Malice is a state of mind that leads one to do an intentionally act out of actual hatred or for an evil or unlawful purpose. It can be established by the 4 things that are up here on the screen: actual hatred or fixed intent or design to do injury, and so forth. So malice aforethought is required of the state. We're going to look at some of the evidence in this case shortly that proves this element overwhelmingly. But this entire case is about Mark Becker's state of mind. And whenever you look and examine Mark Becker's state of mind, you have to look at what he did. Not just what some experts say about it. You have to look at what he did, what he thought, what was going through his head, how he acted. That's what's really important in this case. The amount of time to think before acting, this relates to premeditation as well as how long malice aforethought has to be in existence. The deliberation premeditation need not exist for any particular length of time. It can be really that quick, as long as it takes to pull the trigger on a gun. There is a lot of evidence in this case about Mark Becker's planning. that goes to premeditation, deliberation, and malice aforethought for that matter. Malice can also be inferred from the use of a dangerous weapon, which is what the .22 revolver is. So you're allowed to infer malice from the use of a dangerous weapon. So what I want to do in this case is focus in on Mark Becker's state of mind. I want to look at his state of mind and the things that he not only did, but that he said. We look at not only the things that he did before the crime, the planning and the preparation. We look at the things that he said to people right before it happened. We look at those things, what happened while the murder was taking place. We look at his thoughts and actions afterwards, including the statement that he gave to DCI agent Chris Calloway. We look at all of those things. Can't really separate his state of mind at the time of the crime and whether or not you think, whenever you're examining later on, and we'll talk about later on about the defense of insanity, all of this goes together. It all goes together, needs to be considered as a whole, everything in context. What really counts in this case is what his state of mind was on June 24th of 2009. That's the state of mind that counts. There's been a lot of evidence in this case that's been presented about how he was acting back in September of 2008 and November of 2008, and a lot of history and background on Mark Becker. But what really counts is what was going on June 24th of 2009. That's what really counts. So let's look at the facts of this case. And again, we are looking at these two elements. Mark Becker acted with malice aforethought. That's what the facts in this case prove. And Mark Becker formulated a premeditated, willful, deliberate, and specific intent to kill Ed Thomas in the early morning hours of June 24th of 2009. That's what we are looking at in this case. Here are the facts summarized. Mark Becker planned Ed Thomas's murder. We'll look at the facts here in just a second. Mark Becker concealed his plan from his family and those whose assistance he sought in finding his target. He concealed it. And whenever I talk about those whose assistance he sought in finding his target, we are talking about who? Brian Boozman, Craig Calcorf, all the people that he spoke with, his mom and dad, all prior to that. And he concealed his plan from those he spoke with on the morning of June 24th of 2009. And that would be his mother and father and his brother Scott. Never told them anything about what he was planning to do. He practiced, right? He practiced his plan. He came up with this idea that he was going to kill Ed Thomas, and he came up with a plan to do it. He gets the gun and he practices by shooting at the birdhouse, and knows that he'll have to get close to him at the moment whenever he goes into the weight room or whenever he finds him. So he knows he's going to have to get close to him. He plans it out. He thinks about that. He weighs it in his mind. He knew he'd have to get close to his target, and he did find his target, and he brutally ended the life of Ed Thomas on June 24th of 2009. He left his house with that gun. He got in the Lumina. He had to find the car key, right? He had to use the spare key. He drove. He thought about it. Driving on some of the gravel roads, he thought about what he was going to do. He goes to Applington. He talks to Brian Boozman. tells him about looking for Ed Thomas, and then wants to work with him on the tornado relief fund. He talks to Janice Stahl. He drives to the elementary school where he sees Susan Myers, and he talks to Craig Kalkworth. All the time, he's calm and collected and cool. All the while executing his plan. He then goes to the weight room where he leaves the gun in the car. He peeks into the door, measures up his target, goes back and gets the gun, and brutally ends the life of Ed Thomas. He kicks him. He says, "F you, old man," and he walks out. The best evidence in this case that proves Mark Becker's state of mind is Mark Becker. And that comes in through the interview of Agent Chris Calloway. We are going to examine 3 portions of the defendant's statement to Chris Calloway. All right? What he did in that interview is he gave Chris Calloway a clear, concise story as to what occurred. He was able to tell him all of these things about how he planned it out and went about committing the murder of Ed Thomas. And we're going to look at each one of those and look at some of the photos that we have in this case. We're going to look at it in 3 segments. All right, the first segment is going to relate to what Mark Becker did at his home. How he got into the gun cabinet, broke it open with antlers, and then went out to the bird feeder and practiced. That's the first segment. You will hear in Mark Becker's own voice how he planned to murder Ed Thomas. Ready? Yeah.
Did you get that out of the gun cabinet this morning?
Yeah, I took an antler and broke the handle off the gun case.
Okay.
It was handy, and I pulled the gun out. It was on the top. The first one I picked up with bullets behind me. I loaded it, and he had it locked up. Probably because he doesn't want to get the gun.
Sure.
So I loaded it, went on the back and shot it, wants to make sure it worked. And now I tried and shot it in front to make it work, and then I got in my car. I'm doing this for...
You shot it out back in the backyard?
Yeah, just in the ground.
Okay.
Shot it around, or shot at the bird feeder to see if I could hit it.
Okay.
My aim was true.
So you did hit the bird feeder?
Yeah. No, I don't think I did, but I went anyways.
Oh, sure.
Thinking I just said I was getting really close to one.
You can just leave the lights down. Mark Becker told you through his interview in Chris Calloway how he planned to murder Ed Thomas. By getting into the gun cabinet and the antlers and going through all of those steps where he had the ability to do that and to know what he was doing. The second part of this interview that gives a clear and concise story that Mark Becker told the police about what happened that morning on June 24th begins whenever he talks about how he steadied himself by drinking coffee, and that he then, his parents then left, and then how he went to Applington and talked to Janice and to Brian Boozman, and then he went to Parkersburg. And then he went into the weight room. He got his piece. That's what he calls it. That's what this second part of the interview that I'm going to play here we'll talk about.
What was the first step? What did you do?
I steadied myself. It was about 5 to 7:30.
In the morning?
Coffee.
Okay.
My parents, I saw my parents off, and then once they left, I took a shower. And then I got dressed, and I went to Appleton, and I thought he lived in one of the Appleton houses that were rented out. He wasn't there. They told me he was driver's ed. Stopped by one of his so-called henchmen, and he said he's at driver's ed. Parkersburg, so I'm in Parkersburg, and I went and checked if he was in the weight room. He was in the weight room with backpack. And a piece, a gun, with a tool, and I went and traced him.
And where did you get the tool? The piece?
I got that out of my father's basement.
He went and got his piece. He got his tool so he could go and kill Ed Thomas. The third part of the interview, where he gives a concise version of what happened on June 24th, was whenever he talks about being in his car, having the gun in the seat. He then talks about actually going into this weight room and shooting Ed Thomas, and he describes it in great detail. Mark Becker has the ability to do that, to describe it, to remember it, and to tell Agent Chris Calloway what happened. That's what the third portion of the interview will relate to, and we'll play that.
And then you get in your car. Where do you put the gun when you get in the car?
Right on the seat.
Okay.
And then on the way over, I was kind of moving it to the left, manipulating my mind, thinking if I was to get pulled over, if I saw him right away, what would be the best? So I kept moving back and forth, and then I finally just put it in the car door and said, done with it, until I see him. And then that's when I saw him. And came back out, and I made sure all the kids were clear. And I walked up to him and left-handed, and I put one right in his head, and then I put two more in his head, and then I put one in his knee, so he wouldn't get up. And I finished it off with his skull.
Do you think you shot him 4 times in the head then?
All 6 or 7.
No one made Mark Becker say any of those things. No one forced him. He did this all on his own. What he has told you in these 3 segments of the interview are the choices that he made. He talks about his plan. He talks about how he practiced. He talks about how he executed his plan. And he explains it to us in the interview, what he did. Mark Becker told us that. He didn't say it any better. We hear it in his own voice. So here are the elements of murder in the first degree. We've talked about what Mark Becker's state of mind was on the morning of June 24th of 2009. Now, in examining these elements, you have to apply this burden of proof. And essentially, you have to be firmly convinced of the defendant's guilt. We have to prove beyond a reasonable doubt that Mark Becker committed the act of murder in the first degree, the elements of murder in the first degree, all beyond a reasonable doubt. And the question is, are you firmly convinced? that he had that state of mind, that he had malice aforethought, that he had premeditation and specific intent. Are you convinced? Firmly. That's what the burden of proof is whenever you apply it to the elements of this case. And in applying the elements, or applying the facts of this case to the elements of murder in the first degree, the answer to that is an overwhelming yes. He had malice, he had premeditation. Ed Thomas died as a result of being shot, and it was Mark Becker who shot him. Mark Becker is guilty of murder in the first degree. Now, there are other offenses that are charged in the, or that will be instructed in the instructions that the judge will give you. You start on the offense charged. This is how it works, particularly with an insanity defense. Okay? You start on the offense charged. If we prove murder in the first degree, you stop. No need to consider anything else. That's a lesser included offense. You stop at that point. There's no need to consider lesser included offenses if you believe that the state has proven beyond a reasonable doubt the crime of murder in the first degree. Then you go to insanity. All right? That's when you go to insanity. Back up 1 second. So just to state it one more time to make sure that I'm clear. Murder in the first degree is the offense that is charged. 4 elements, like we've already talked about. Look at those 4 elements. Make your determination: is Mark Becker guilty of murder in the first degree? No need then to go to the lesser included offenses. You then, after you've made the determination of guilt, go to the insanity defense. That's the steps that you have to follow in this case. The state, in this case, has met its burden of murder, is that Mark Becker is guilty of murder in the first degree. We have that burden. Now, whenever we're talking about insanity, the defendant has the burden of proving insanity, that he was legally insane by preponderance of the evidence. I'm sure Ms. Flanner will talk to you about that and what that means. But then we will address the defendant's insanity in our rebuttal argument. I'll have another chance to stand up here and talk to you folks about this case as it relates to insanity. So those are the steps that you have to take. You know what the burdens of proof are. You know what the state's burden of proof is. You will know what the defendant's burden of proof is as it relates to insanity. Lastly, I will tell you this. The facts in this case can only be characterized as brutal. Mark Becker is the one who committed this brutal act. Mark Becker made his choice. He's the one that made the choice. It is his responsibility and no one else's. Mark Becker made his choices on June 24th of 2009. And Mark Becker is guilty of murder in the first degree. Thank you.
Anytime, Your Honor.
Have a seat, please. Ms. Flander for Mr. Becker.
May it please the court, counsel.
Ms. Flander.
Good morning, ladies and gentlemen of the jury. Thank you for your patience for the last 2 weeks. This is the opportunity that we have to argue our case, tell you what the defense believes has been shown. It is without dispute that Ed Becker was a very well-respected person. That is not the issue in this case. The issue is that Mark Becker was insane on June 24th, 2009, when Coach Thomas was shot. You always hear tones of voices that can be derisive or sarcastic or emotional. That doesn't change the evidence. And the jury should look at this sometimes without emotion so they can make the fair and just decision. And what we are looking is at evidence that has been presented that Mark Becker was insane. Dr. Philip Resnick, who is a forensic psychiatrist, a professor of medicine, a person who supervises and mentors other forensic psychiatrists during fellowships, teaches other forensic psychiatrists how to do forensic psychiatric evaluations, told you how to do a psychiatric evaluation. And that is basically what the evidence has done in this case. The evidence has taken you, the jury, through a psychiatric evaluation. So when we look at that evidence, we start with Mark's history. Joan Becker testified regarding Mark's childhood and adolescence. And that testimony included clues to the onset of schizophrenia when he was in high school, with depression and withdrawal. Mark played football for Coach Thomas, and even though he was suspended for a couple of games, he returned to the football team as a starter. There is no evidence in this case that Mark bore any kind of grudge against Coach Thomas. None. But on September 8th, his schizophrenia was quite clear. And it certainly shows Mark's descent into the abyss of insanity that was apparent on June 24th, 2009. And we can look at what the evidence presented. Joan Becker testified that on September 8th, she woke up. Mark was yelling, "Get off me." He came up the stairs. She didn't know the person that came up the stairs. Mark did not recognize them as Mom and Dad. He called them Joan and Dave. And that is consistent with other episodes that she described throughout. And as you have seen throughout the evidence, Mark can go up and down. He can be calm and upset, calm and upset. His eyes looked different. His eyes looked through you. His face was different. It seemed larger. And his voice deepened. He was swearing. That he had never done in front of his mother before. He had vulgar body language. He was hitting doors, walls with a bat. He broke things. He may have even taken his coach's photograph down from the wall, the poster. That was State's Exhibit, I believe, 37 or 39. His fits could last for hours. He could drive away and come back. She's described that, as we'll see later on. He kept saying, "Get them off me. Can't you see them?" Clearly showing visual hallucinations that he continued to have periodically from September 8th through June 24th, 2009. He thought he was being turned into his coon dog chief. He threatened suicide. He threatened to beat up a couple coaches. And he believed Coach Thomas was trying to rape him. He was delusional. Coach is behind me, raping me, get him off me, I can't stand it anymore. Sheriff Johnson was called. Sheriff Johnson saw him on this date. Sheriff Johnson had contact with him from September 8th, 2008 through June 24th, 2009. He could see Mark going from moody to calm to agitated. And that's exactly what you see in his videotaped interview with Chris Calloway. Mark said he had an ESP connection with Coach. Coach's messages were keeping him up all night, and Sheriff Johnson signed an affidavit for the committal. Now, you may have heard testimony, if you recall, about Mark's drug use after high school. And you heard testimony from two friends that described him when he was using drugs, who described his actions when he was using drugs. But even one of the witnesses says he didn't talk about the white power. And when they saw him later, as we'll see, it didn't appear to them that he was using drugs. Dr. Mark Lassise testified because on September 8th or 9th, he was committed to Mercy Hospital, hallucinating and hearing Coach Thomas's voice, having bad dreams and perhaps nightmares. Mark Lassise, the psychiatrist at Mercy Hospital, testified regarding schizophrenia, started educating us about schizophrenia. It is onset, late teens, early 20s, the typical age of a young man with schizophrenia onset. Patients try to self-medicate. They try substances in hopes that those substances will make them feel better. That is common among people with schizophrenia. The legal medications that are prescribed by doctors take 3 to 5 days to take effect for paranoid schizophrenia. And you must adjust those medications over time. And if you take doses for 2 or 3 days and stop, the therapeutic benefit diminishes. And we saw that happen after he was taken to the hospital on June 21st, 2009. The doctor said you can't predict delusional episodes. They can be continuous, they can be intermittent. And there is a higher non-compliance with medications that are used in this type of disease because those medications are not user-friendly. They make you feel bad. When you take the medications, you feel better in your mind, but you recognize how bad the medications make you feel, and then because you're feeling better, you don't need the medications. So you stop. It's a typical schizophrenic outlook regarding the medications. When he's released from his committal, Mrs. Becker testified of continued episodes that escalated. She described an incident when she had picked him up from Waterloo, that she contacted the doctors, and on about November 23rd, after another episode, she called the doctor at 5 East Mercy Hospital, talked to Dr. Armstrong, who ordered a pickup. He was hospitalized again. This history is important because, as Dr. Resnick said, this is the first part of your forensic evaluation in trying to reach an opinion as to whether or not Mark was insane on June 24th. This is important. Dr. Mark Lassise, again, was his attending physician. Mark was experiencing much more intense psychotic symptoms, hallucinations, and paranoid delusional thinking, and he was still receiving telepathic messages, at least from his parents. The start of the descent into insanity. After Mark's release, the episodes continued. They could happen instantly without warning, continue for an hour or days. An episode was taped and was actually seized by the Division of Criminal Investigation. So there is a tape recording out there of an episode. Judy Argis testified that Mark began services on April 15th, 2009, and described some of the things that he talked about because he wanted help. He couldn't feel water in the shower. Someone was putting their thumbs over his eyes. And that was a consistent theme from some of our witnesses, that he talked about pressure on his eyes. Couldn't sleep. He could sleep a lot, or he could sleep not at all. She believed she saw him hearing voices and described how Mark acted when he was hearing those voices. You have an opportunity to actually see that on the videos. You can see him and how he reacts when it looks like there may be somebody talking to him in the corner that nobody else can see. He would pause during conversations. He would turn away. He was on edge. At staffing, he was quiet, looking at the door, distracted. He kept appointments with the Black Hawk Grundy Mental Health, wasn't taking any medications, and she testified. Schizophrenics periodically have dangerous episodes, but they can then live safely in society. They have those periodic stability, but then can have the episodes in rage. Very consistent with the doctors' talk about how schizophrenics act. Joseph Foster was a friend of Mark. He saw Mark a month prior. No alcohol, nor did he appear to be using drugs. And he is one that had actually seen Mark using methamphetamines. He would be jittery. He would be on edge. He would be hard to talk to. But he saw no signs of that the night he saw him. No signs of methamphetamine, which would be consistent with the UA on June 24th and consistent with all doctors who said any psychosis on June 24th was not methamphetamine abuse. But when his wife came out that day, Mark did a 180. He'd seen a disgusted look on Mark's face, one that he had never seen before. He was very angry in an instant. He didn't look like himself. He didn't look like himself. Very consistent with what Joan Becker had seen on September 8th and continued to see over the course of Mark's descent into insanity. He never heard Mark complain about Coach Thomas. And although motive isn't required, there's no motive in this case, or at least there is no rational motive. Eric Kalkworth had seen Mark using drugs. He would be hyper when he was using drugs, but there were no statements about Satan or white power. None. It was a different Mark from high school, but he didn't talk about Satan or the white power or the white authority. And after Mark's hospitalization, his personality was not like when he was using drugs because he wasn't hyper. He had gained weight. He still wasn't like he was in high school. But he wasn't like when he was using drugs. He would take a long time to answer questions. He saw Mark about 6 times in 2009. He was pretty quiet, withdrawn, and one time he was mumbling to himself. He was a different person than who Eric knew in high school. Approximately on June 18th, he saw Mark, and he seemed to be the Mark of old. He was friendly, and again, he didn't think Mark was using drugs. Jason Key and Clint Dolman, who did coaching at Parkersburg, had never heard Mark express any type of animosity towards Coach Thomas. And Leon Schwartfeger saw Mark on June 10th, 2009 at a church camp. Mark was tense and searching for peace. Said, "The devil keeps messing with me." He could see the devil. He could describe the devil. And that devil had different forms. And Mr. Schwartfeger prayed with Mark after Mark had described the pressure on the eye sockets. And he told Mark to cast the devil. And then Mark left. So as we can see through this history, there were times that Mark was calm. He was himself. And then he would change. He would see the devil. This is consistent with his history leading up to June 20th, 2009. Jeremy Cloberdance, who is Mark's co-worker at Old Chicago, and who Mark trained in making pizza dough. There has been evidence that schizophrenics can work. They are able to work. And just because you're schizophrenic does not mean that you can't teach somebody how to make pizza dough if that is what you are doing for a job. Doesn't mean you're insane at that time. But you could certainly teach somebody how to make pizza dough. And it certainly doesn't mean you're not insane on June 24th. Mr. Cloverdance also described a time when he saw Mark taking a drink of water. His eyes rolled back, his body shook, and he shuddered. And he seemed surprised where he was, like he'd just woken up. As if Mark had not been there, when he had been there for several hours. He described Mark as a loner and reserved, similar to Mr. Cloverdance's personality. But Mr. Cloverdance said Mark might have been like a piece of furniture. He didn't describe himself as a piece of furniture. And on June 20th, not too long before the high-speed chase, Mark was happy because Jeremy had actually paid him $2 to work a shift. $10 made Mark happy. When he got off work, Joan Becker either saw or talked to Mark Becker about 45 minutes prior to the sheriff calling to tell her Mark was okay. Well, she knew he was okay because she'd either just seen or talked to him. So in a short period of time, he went from being happy to going to Dwight Rogers' house for no reason, except Mark believed Mr. Rogers had been hypnotizing him since childhood with a teddy bear. No reason. Dwight Rogers says he was not in preschool with Mark, and although he did know the Becker family, but Dwight Rogers says he had not hypnotized Mark or put a spell on him with a teddy bear. But Mark, in his delusions, believed he had been hypnotized. And then there was a high-speed chase. And we know that that chase ended after Mark hit a deer as he was traveling in excess of 90 miles an hour. When he got out of the car, he laid on the ground. Somebody had a weapon pointed at him. And Sheriff Johnson testifies as to what Mark yelled. "Get Satan out of it right now. Trying to free myself. He's Satan. He's Satan. He's got everybody hypnotized. I feel like I'm a deer. Why can't the cops get down to this and finish him off? Get me free." And there's a video of Mark in the Butler County Sheriff's booking room after he was brought to the booking room. And Mark is yelling, "I work for God, I don't work for Satan." He went over to Satan's house because Dwight Rogers had hypnotized him since he was a little kid. Says apparently Sheriff Johnson is being Satan right now. And then he was willing to work with you. He was willing to work with Sheriff Johnson. He's not trying to work off any charges or reach a deal. He thinks he's on the right side of the law, even during and after this eluding incident. He wants to work for the police. And when you watch that video, you see Mark ranting, but you see him sitting calmly. He's up and down. Chief Luring also saw Mark after the high-speed chase and admitted that Mark was yelling, depending on who was asking the question, either interesting or bizarre comments. And he heard basically the same comments that Sheriff Johnson heard. Dwight is Satan. He's got everybody hypnotized. I feel like I'm a fucking deer. Why can't the cops get down to this and finish him off? Get me free. He wants to be free, even on June 20th. help me out. He's got all of you under his spell. He's hypnotized everybody. He uses a teddy bear. And on June 20th, Chief Luring did field sobriety test, and in his opinion, Mark was not under the influence of alcohol, drugs, or a combination of those substances. Sheriff Johnson was concerned enough that he transported Mark to Covenant Hospital, where he was admitted to the psychiatric unit. And you can see his behavior during the booking room, up and down. But Nurse Gowans, who takes the medical history, says Mark was calm when he got there. He said he'd been off meth for 40 weeks, and she didn't see that he was underweight and he had no teeth problems. Again, doesn't appear there's any methamphetamine use. And then he sees the doctor, Dr. Cantim-Nemi. He sees another psychiatrist first, but Dr. Cantim-Nemi is the treating physician. And the jury instructions will tell you that you can consider the bias and interest of the witness in determining the credibility of their testimony. And Dr. Cantim-Nemi is very biased in this case. She has a great deal of interest in this case because she's the one that authorized Mark's release on June 23rd. The medical records show that when Mark was admitted to the hospital and during the course of his hospitalization, there were auditory command hallucinations. Voices were telling him to do bad things. He thought he was under a spell. There were visual hallucinations. He was seeing Satan. He was being controlled by a rich satanic cult. He thought he was hypnotized. Voices were telling him to kill. He saw a conspiracy in the community in a satanic cult. He had a dose of Gideon sometime Sunday, had some other medication on Monday and Tuesday morning, and was discharged from the hospital. And there was testimony that if he didn't take the medication again at 8 o'clock that night, the therapeutic benefit would decrease. He was discharged with a prescription. His caseworker picked him up, and you heard Adam Taylor explain why the prescription wasn't filled. And Adam Taylor testified nothing suggested to him that he was using drugs. He was generally cooperative. He was happy with services, even though at times he appeared agitated. He described seeing Mark in the hospital on June 22nd. He was easily agitated. His anxiety would escalate. He was up and down, as we've seen throughout all the episodes that have been described. He seemed anxious, appeared delusional. His parents were robots and against him. There were times he thought his mom and dad were against him, when he didn't even see them as mom and dad, because they'd been suppressed by Coach Thomas. On June 23rd, he was not as up and down. He picked Mark up, but didn't take him to get his prescription filled. It was late, and he didn't know where the prescription was. Now, Mark apparently signed discharge papers with that information, but even Adam Taylor didn't know where to get that prescription. Adam Taylor admits that clients don't always do what he suggests. And there is certainly some question about why Mark walked to the Burger King, whether or not he had food in the house, whether or not he knew the door was unlocked. He's schizophrenic. He hasn't had his dose of medicine. His mind does not work normally. He wakes up the next morning after hearing voices, and you hear that on the tape. Mark describes in great detail waking up, that he can't breathe, and he's hearing voices. And he leaves his parents' house. He sees Brian Boosman, who's a jogger, who testified that Mark was very likable in junior high, although he lost Mark after that, lost track of him. Mark referred to him as a henchman. He was Coach Thomas's henchman, apparently believing that Brian Boosman is part of this conspiracy. He had also seen a Miss Stahl, who he later described as a witch, which would be part of a satanic cult. He saw Craig Cockworth, who said Mark was usually quiet and usually wouldn't make eye contact, but on June 24th, he seemed a bit happier. But he also called him Mr. Cockworth, which he'd never been called before. And although there is testimony that Mark acted normal, most people that saw him that day didn't know what normal was for Mark Becker. There were some young children, young kids at the weight room, and that's tragic, that they had to see anything that happened. But Brandon Simpkins testified the person who came in couldn't talk right. He was stumbling and stiff-legged. Damian Menon said he yelled, "Fuck you, old man," but he had a blank face. He glared at Damian when he drove away. That Mark looked normal. Of course, he didn't know what normal was for Mark, because he certainly didn't know about the mental health history that Mark had, or the schizophrenia from which he suffered, or the insanity that was in his life at that moment. Matthew Wicks confirmed he had a blank look. He was yelling, "Stupid son of a bitch." His demeanor was angry, but he was a blank slate, which also shows the differences that Mark's facial features could take in a short period of time. Joshua Schwartz had seen Mark at weightlifting, so he would actually know where Coach was. Mark was involved with the football program. He was involved with football. He would know where Coach Thomas was. He'd actually been at weightlifting earlier in the year. Joshua Schwartz testified he saw a gun in his right hand. We know that Mark is left-handed. On the interview, he says right, left, both. Perhaps he is ambidextrous. Perhaps the kids were so traumatized, and it's likely that they're mistaken. Doesn't mean they're wrong. It just means they mistook one fact. You heard the gun clicking, heard him yelling, "Fuck you, old man," but he didn't speed away. He didn't act guilty. He didn't act like he had done something wrong. Other witnesses were seeing him at the time. Robert Jansen heard him yelling at the coach. James Martindale III heard the gun clicking, heard him screaming and swearing. He drove away yelling, "No one fucking does this." But he drove away at a normal speed because he doesn't think he did anything wrong. Because he thinks he did right. Because at that time, he was incapable of distinguishing between right and wrong. Pastor Smith heard Mark upset and yelling. Tiffany Fry says he stumbled around in circles. He was yelling, looking angry and frustrated. And he was yelling, "Make sure Satan knows," and other things about Satan and the devil. He was doing things that weren't normal. Ashley Farley heard him say, "Thomas is Satan. Thomas is not God. Go get his carcass." A carcass is the body of a dead animal. Because he thought Coach was Satan. He thought he did right. Sheriff Johnson saw him immediately after. Now, it's not surprising that when Mark sees the car, the sheriff's car in his parents' driveway, and Sheriff Johnson said he had his gun out and that Mark could probably see him, that Mark got out and got on the ground, because that's what happened 4 nights before. And he says, I'm done, I'm done. Ed is done, and I'm done with Ed. I stomped him for you cops. Now, the police didn't ask him to do it, but Mark thought what he did was right. He was doing it for the police. He was doing it for the little children. Because he was insane at the time Coach Thomas was shot. He would work for anyone, the cops, the FBI. He was rambling. Deputy Lubin testified in the car from his parents' driveway to the booking room. It's better for the community. That's all I know. It's better for the community because he thought he did right. There's so much heavenly power now you don't even know. Satan seems like a rag doll to me because Satan is gone. It is a good thing to kill Satan because he doesn't recognize that he killed somebody other than Satan. Mike Crapfel collected a UA. Mike Schmidt got the UA from Crapfel and took it to the lab. And he seized prescription drugs, which we knew he had some, but not enough to make a difference in his schizophrenia and his insanity on June 24th. You have the videotape of Mark in the booking room before Agent Calloway came in the room. And I've just summarized some of the things that Mark has said. To look at the video shows Mark while he says it, shows how he reacts to what he's saying. Clearly demonstrates that he is seeing something that nobody else sees. I work for one person, and that's the true white God. The devil's among us. Let fate take its course. You're free. You're free to go. And for that, we're in the hands of Lucifer. Let the light shine through the authority now, God. Let it shine through the authority now. Because he did something right. Let there be no more Satan, brainwashing. Just stop and watch. Let there be freedom. Don't be afraid to be happy. Get this monster away from me. That's what he says. He's in the booking room alone. But he needs the monster to get away from him. Because his insanity has continued from the weight room to when he's in the booking room. Get the head, he's done, he's complete done. And law enforcement, just leave him alone in the booking room while Agent Calloway is preparing on his drive to Butler County what he's going to talk to Mark about. And Agent Calloway testified, even if he'd known his medical history, he wouldn't have changed his interview with Mark. Well, actually, there would be nothing to change because Mark is paranoid and he is delusional. Dr. Taylor suggested that the hallucinations or delusions didn't affect the interview with Agent Calloway. But you can clearly see that Mark didn't track a lot of the interview. You can see during the actual interview that he is up and he is down. And he is talking in very weird sentences. You have the video, so you have not only what you can hear, you can also see Mark. And it is important to not only hear what Mark said in its entirety, but you can see how he said it in its entirety. It is fine and good to pick out portions of an interview that support your case. But you have to listen to it in its entirety when you're looking at the insanity issue. And the defense has picked out portions. We start with Agent Calloway asking him if he's okay. He asked him 4 times. Actually, Jason Johnson, the sheriff, asked him the first time. Are you okay? And Mark's reply is, I've got to get this disease off me. It's fairly non-responsive, but it does demonstrate a tactile hallucination. There's something on him that's not there. It shows from the beginning of the interview that Mark is having at least some hallucinations. And then the 4 times that Jason Johnson asked him during the interview, are you okay? Chris Calloway, how are you doing? Mark Becker, pretty good considering I'm working for the white, the only true power that exists on earth. He doesn't say I'm good. He doesn't say I'm fine. He's talking about working for the white power. Chris Calloway, are you okay? Mark Becker, it's just deep-seated animosity. Animosity against what? Doesn't have anything to do with whether he's okay. Chris Calloway, how do you feel right now? Mark Becker, my anus hurts a little bit, but that's it. And my front side hurts a little bit, but that's it. I don't know why. I don't want to be touched right now. Normal conversations don't include talking about how your bottom feels. And it certainly is an indicator that Mark is not in the present during the interview. And later, Mark is saying, I got it, get Satan out now. Do you have the power to get Satan out of here? Chris Calloway says, I don't. Are you okay? Mark says, yeah. And Chris Calloway says, can I get you something to eat? Would that help settle your stomach? And Mark says, right now I'm Satan. For some reason I envy you. Damn Satan, damn you, I'm ready to join the team. Now, he's not offering to work off any criminal charges. He thinks he's done right. He's going to work for the police because he has done right. And then we have Mark's statements, which, if you take throughout the videotape, certainly shows his state of mind and shows that he was insane in the weight room on June 24th. Mark's statements, like I said, I'll work for anyone but the devil. I'll work for the feds, the sheriff, the police, anybody but the devil. It hurts me to see all these children suppressed by somebody so long. My mom and dad too, and me, my brothers, were all suppressed by this devil tyrant for so long. They were suppressed by the devil. And Mark has taken care of the devil, apparently, and freed people. Now it's gone, pull myself together, sir. But he's unable to pull himself together for the course of the interview because he again gets agitated. He's up and he's down. I feel like I have death in me right now. It's in my lungs, it's in my nostrils. And you actually see Agent Calloway looking in his nostrils. Mark says, I'm telling you, I have a firm hold on Satan right as we speak. All I have to do is clench my right fist and he's gone. He talks about he's tired of licking cotton. Again, he talks about the devil being the devil tyrant. He's suppressing the children. We can hardly breathe at night because of that man. He turns us into fish and he turns us into animals. Satan does things to Mark in his delusions, in his hallucinations. They, the voices, told me to take him out. He was being the devil. He was being Lucifer. The only way for the children to be free is if he was gone. I could see that visually. He thinks he's doing right because in his insane state of mind, he doesn't understand and cannot distinguish between right and wrong. His statements continue throughout the interview. But I saw the devil in another person, and I went to his place, but it wasn't him. And I know he works for him. He's part of the henchmen. That's Brian Buseman, who believes Mark was acting normally. But Mark had no reason to go to Applington because his involvement with the football program would mean that he would know where Coach Thomas was at that time of morning. Except he was deluded and having hallucinations, and he was insane. He was acting like he was a man of the universe. And Mark describes what he said when he walked out. I said, "Be free," because he thinks he's done something right. He yelled it at the top of his lungs. I said, "Be free." And then he felt drained. That's what he said to Chris Calloway after he described what happened. He felt drained. But he also didn't want Chris Calloway to go satanic on him. He started talking about wearing less cotton because he's tired of licking it, and they have him brainwashed, and he talks about the tyrants. And then he says, I feel like I've been dead my whole life. And now he's waking up because the devil is gone. Then Chris Calloway said, when was the last time you ate? And Mark says, I've gone weeks. Again, non-responsive. Perhaps he didn't have anything that morning. Perhaps he didn't have anything the night before. But surely he ate while he was in the hospital, which is only two days before or the day before. Mark talks about suppressing Chris Calloway with his right hand. He literally minimized a huge Satan tyrant. And then Chris actually asks, and you squeeze your right hand to prevent that from happening or prevent evil from happening? Mark, yeah. Well, to prevent war and peace. He's almost omnipotent because he can prevent war and peace by squeezing his right hand. That's a delusion. That's an hallucination. That is insanity. It has continued from the weight room through the interview with Chris Calloway. It's as selfless as I can be now saying that it wasn't me. 100% it was God. He sent angels away. He talks about the burden being lifted. He then describes the devil, which, if he is actually seeing the devil, he should be able to do. And he does describe the devil. I got it, get Satan out now. He's seen something, and he wants Chris Calloway to get Satan out and ask Chris Calloway if he has the power to do so. But Mr. Calloway says he doesn't. But then Mark sees Chris Calloway glowing. You're glowing. I can see it in your eyes. Yeah, they're shining right now. This is the interview that establishes Mark Becker's insanity on June 24th, 2009. But then Mark is booked into jail, and there has been description then of how Mark acted while he was in the jail, and then as he was seen by the nurse practitioner in the subsequent days and weeks. Mark continues to talk about being a hitman. He doesn't know right from wrong because he believes that law enforcement hires hitmen. Then he doesn't see Satan, but then he talks about he's got the flutter of Lucifer in him. He's booked in the jail. He's moving around, touching the walls. He touches himself in various ways. He's shadowboxing. He touches himself a few times, takes his clothes in the shower, gets them out of the shower, and then he bathes in toilet water. And then Nicole Amos saw him. He continues with his delusions and with his insanity through at least the first several weeks that Nicole Amos sees him. She saw him the Saturday after the shooting. He's delusional. He is having hallucinations. He saw frozen sharks, called Coach Thomas Lucifer, Didn't show remorse because he didn't do anything wrong. He had a blank stare, calm with a flat affect. He was not agitated, minimal eye contact. Seemed paranoid. He was glaring at the nurse when she was writing things down. He was diagnosed with schizophrenia. That was the practitioner's diagnosis. He was medicated. She thought it would be about 7 days before you saw a change. When she saw him on July 1st, she testified that during the course of the time since she'd seen him before, he was masturbating inappropriately 4 or 5 times a day. His mental status hadn't changed much. He was not as talkative, but he was quieter and calm. She did not see a change in his behavior. She saw him again on July 8th, still having delusions, having negative withdrawal, although he denied hallucinations, which again is not uncommon in schizophrenics. She upped the Seroquel. On July 22nd, he was more balanced and steady. He discussed prior auditory hallucinations. He blamed everything on the guy he shot because he didn't know right from wrong, because the guy he shot was Lucifer. He was Satan. And she increased the medication. So what we have learned is that the 5 doses of medication he had in Covenant Hospital did nothing for him, because it was almost a month of medication before there was much of a change in him. And even Dr. Spodak says when he interviewed him in January, it wasn't as long as normal because he had been medicated for so long. So if you look at the videos and the interviews in its entirety, not just bits and pieces, as the state and I have done here, you can look and see that Mark was insane. There has, wait for a minute on the next one. No, you go ahead and take that one in. There has been some talk about the choices Mark made, that he chose to have coffee, he chose to break into the gun cabinet, and that's exactly true. But Dr. Resnick explained the concept of rationality within irrationality, that it is not uncommon. Dr. Spodak and Dr. Taylor didn't disagree with that concept. They simply ignored it. Because if they address it, it brings their opinions and conclusions into question. And because they ignored it, it just doesn't exist. Although Dr. Resnick testified clearly about it, Dr. Spodak and Dr. Taylor's opinions and conclusions are brought into question. You have to do the complete psychiatric forensic examination. You can talk about where it is, as long as it's in a private place, then it's a valid place. Dr. Taylor met with Mark somewhere between 60 and 90 minutes. He doesn't have a report, and Dr. Resnick explained why reports are important, because it forces you to write down the reasons for your opinion, and it subjects your opinion to rigorous examination. Dr. Taylor was looking at 2 issues, not one, for an hour to 90 minutes. He makes a sensational, almost undocumented account that perhaps Mark was going to take out the entire Thomas family. But if you listen to what is on the videotape, even though there are quite a few of inaudibles there, it is just as likely Mark was talking about his own family. It's just as likely. Dr. Resnick was able to write down all of the reasons that he believed Mark was insane during his lengthy conversations with Mark, when he actually asked Mark to explain what he might have been thinking or seeing or feeling or smelling. So we start with the concept of rationality within irrationality. That is undisputed. And as Dr. Resnick testified, there is no inconsistency between careful planning and legal insanity. Just because you can plan doesn't mean you are not insane. There's no inconsistency because of the concept of rationality within irrationality. We look at the forensic psychiatric evaluation. You take this psychiatric history, you look at the statement to law enforcement, and the account of the offense. You look at insanity. Diseased or deranged mind. Mark had a diseased or deranged mind on June 24th, 2009. And because of that, he was incapable of knowing the nature and quality of the act, and he was incapable of distinguishing between right and wrong in relation to the act. He was paranoid schizophrenic. That's undisputed. Now, just because you're paranoid schizophrenic doesn't mean you're insane. But you have to look further. He had delusions. Ed Thomas was raping him. Ed Thomas was Satan. Ed Thomas was brainwashing him. He believed he was hardly able to breathe. He believed he could prevent war. Those are some of the things that Dr. Resnick considered. He had hallucinations. He heard the voice of God. He heard the voice of Ed Thomas. He had disorganized speech, and he had a negative drug screen. So his paranoid schizophrenia was not induced by illegal substances. And again, these are just some of the things that Dr. Resnick described in reaching his opinion and conclusion. Basically from what he outlined on the largest legal pad in the world. He didn't understand the nature and quality of the acts because he believed Ed Thomas was literally Satan. He did not believe that Ed Thomas was a human being, and he referred to a carcass, which is the body of a dead animal. And he didn't understand the consequences. The consequences of this were he was going to end the supernatural activity of Ed Thomas. He was going to break the ESP telepathic connection that Ed Thomas had with him. He was going to free the children. If you look at the entire medical history and the interviews, you can see that Mark did not understand or was incapable of understanding the nature and quality of his act. Incapable of knowing the nature and quality of the act. He also was incapable of distinguishing between right and wrong. Dr. Resnick again summarized briefly on his notepad, but explained in greater detail why he believed Mark didn't know the difference between right and wrong. First of all, there was the interview. I think it was right. He thought his action was right. He was free of guilt and shame. He believed he was acting lawfully because he was helping the police. As he said, I did it for you cops. He offered to be a hitman. He believed he was the agent of God, that he was on a mission from God. God was pleased with Mark's actions because he saw Coach Thomas as evil. God saw Coach Thomas as evil. Mark didn't try to hide what he might have done. He didn't flee the jurisdiction. He drove home. He didn't wear a mask. He did not try to hide his identity. He did not act like a criminal. He believed he was freeing children. He believed he was ending rape. He believed he was ending somebody turning him and others into animals. The defense has met the burden above a preponderance of the evidence that on June 24th, Mark Becker was insane at the time Coach Thomas was shot. He suffered from a diseased or deranged mind. He was incapable of knowing nature and quality of the act. He was incapable of distinguishing between right and wrong. And there is no rational motive for the action. None. They appeared to have a good, if somewhat distant, relationship. There was no reason. There was no real harassment. Whatever harassment there was in a deluded and insane mind. And therefore, at the end of your deliberations, we would ask you to bring back a verdict of N, not G, guilty, R, reason, insanity, I. NGRI, not guilty by reason of insanity. Thank you.
What I want to start off with is Mark Becker's sanity. What the defendant wants you to do in her closing argument is almost to do kind of your own forensic evaluation of him. What we're asking you to do is a common sense evaluation whenever you look at the facts and circumstances in this case. Defense counsel spent nearly 50 minutes of her closing argument talking about symptoms of paranoid schizophrenia. What have we said from day one in this case? We have no dispute that he has paranoid schizophrenia. I mean, even one of our own doctors had characterized Mark Becker that he's a sick guy. That was Dr. Spodak. We don't have any dispute that he has a mental illness. But we also said in this case that mental illness does not equal insanity. It just doesn't. There is a legal standard that you have to apply to Mark Becker. Let's look at insanity as cause and effect. If you're thinking that defendant suffered from mental illness, paranoid schizophrenia, that condition caused or contributed to his decision to kill Ed Thomas, therefore the defendant is insane because he is mentally ill. This is not the standard of insanity. This is not the legal standard in the state of Iowa. How about this notion? The reasons for the defendant's thoughts and actions cannot be understood by others. The defendant made unusual statements. There's no dispute that he made unusual statements. Therefore, he must be insane. This is also not the legal standard in the state of Iowa. It isn't. How about this notion? Some of the circumstances. The defendant killed someone in front of eyewitnesses. Only an insane person would do such a thing. What, crimes don't happen in front of eyewitnesses? How many times have we heard on the news when some guy takes a gun, goes into a bank without a mask and 15 cameras watching him and robs the place? Does that make that person insane, legally insane? Just because they do it in front of eyewitnesses? This is also not the standard of insanity in the state of Iowa. It is not the standard. What is it then? In order for the defendant to establish by a preponderance, or to establish he was insane, he must prove by a preponderance of the evidence either of the following. This is the standard of insanity in the state of Iowa. Number one, it is the defendant's burden of proof. And secondly, he has to show that by a preponderance of the evidence. And then there are specific elements to the defense. Does that make sense? That we have rules like this that we follow? What are they? At the time of the crime, he did not have sufficient mental capacity to know and understand the quality of the acts with which he is accused of. If he shows that he does not have the mental capacity to understand the nature and quality of his acts, and he does that by preponderance of the evidence, he is insane. If he can't make that burden, he is legally sane. The second part of the test, excuse me, is at the time of the crime, he did not have the sufficient mental capacity to tell the difference between right and wrong as to the acts with which he is accused. If he shows this by preponderance of the evidence that he does not have sufficient mental capacity, he's insane. If he doesn't meet it, he's sane. That's the legal standard in the state of Iowa. The judge will tell you that shortly in instructions. Let's look at some other standards that apply in this case. First of all, the defendant is presumed sane. Again, it is his burden of proof. The evidence in this case overwhelmingly proves that he had the mental capacity to understand the nature and consequences of firing 6 shots into Ed Thomas's body. It also is overwhelming in this case that he understood the wrongfulness of those actions. What we're going to do is look at everything in this case. Statements that he made, actions that he did on the day of June 24th of 2009. Look at those things. In the whole realm of the analysis of this case, it's been brought up concerning what the defense doctor, particularly what Dr. Resnick said in this case. And he has this concept of rationality within irrationality. This is something of Dr. Resnick's own making to try to explain his opinion. This concept has no basis in the standard that you're to apply. It's not part of Iowa law. It's not part of any jury instruction that you're going to get. All right? This is his concept, Dr. Resnick's concept. And you know what? Really, the defense can't have it both ways, right? I mean, it really kind of makes no sense. The standard of sufficient mental capacity, if you have sufficient mental capacity to do a lot of things, then how can you not have sufficient mental capacity to understand the nature and quality of your acts, to understand the difference between right and wrong? It sort of doesn't go together, right? Well, why not this? Why not irrationality within rationality? Why don't we just have this whole, instead of irrational behavior in some parts that are rational, why not just flip it on its head? Wouldn't that make just as much sense? If we're going to use Dr. Resnick's model, his phrasing is simply not part of Iowa law. What you have to do is come back to those standards that the judge gives you that we just talked about and apply those standards to the facts in this case. One of the other notions that Dr. Resnick talked about, and that's been mentioned here multiple times by defense counsel, is that the defendant was literally seeing Satan. That he was literally seeing Satan. Satan and the devil tyrant are something that Mark calls Coach Thomas. We don't know that he's actually seeing it. He calls him that. He does say it. We can't dispute that. But isn't it just as plausible that he's figuratively talking about it? I mean, what if, let me give you an example. What if Dr. Resnick, we'll use him as an example, if we were walking out into the hallway after his testimony, and I said, boy, that Dr. Resnick, he thinks he's a god of psychiatry. Right? Would be a critical statement of Dr. Resnick, but I would be using the word God figuratively. Isn't it just as plausible that that's what Mark Becker is doing? It's something that he called it. It's that simple. We don't know what he was actually seeing. What he gives us evidence that he's actually seeing is that it's Ed Thomas that he's shooting. He uses his name multiple times. We'll talk about that here in a second. Rogers didn't even apply the Iowa standard. Dr. Rogers wasn't even brought up in the defense counsel's closing, but he didn't even apply Iowa standard. And the last thing with regard to the defense doctors, one of the last things, is if you consider his past, you've got to consider his drug use. All of these things that happened in his past, in September and November of 2008, all happened whenever Mark Becker was using meth, using cocaine. All of his friends and buddies got up and talked about some of that. That is certainly a factor. We have no dispute that his urine or blood, whatever it was that was tested, came back and he didn't have meth in his system. But whenever you examine those other things that happened in his past, this is a big part of it. And that was his meth use back in September and November of 2008. If Ed Thomas was literally Satan to Mark Becker, again, we've talked about this just a minute ago, as Resnick says, then why wouldn't Mark Becker be doing some other things if he's truly thinking that he is shooting and killing the devil himself? Shooting and killing Satan himself. He would be, as Dr. Spodek said, shouting it from the rooftops, telling people that's what he's going to do. Because if it's something right, why would you conceal it? Right? If it's something right. He would be disputing his arrest by Jason Johnson. He would be asking why he's talking to Chris Calloway, right? I mean, if it's right in his mind, if he's got this distorted perception of right and wrong, and you're getting arrested for something you just did right, why aren't you saying, it's like, why are you cuffing me? Why aren't you giving me the key to the city? Why aren't you throwing me a parade? Right? I mean, but he doesn't do that. And he also doesn't, whenever he's talking to Agent Calloway, here he is in a custodial setting at the sheriff's office. Whenever Chris Calloway is talking to him, he reads him his Miranda warnings very carefully. Mark goes over all that with him. Not once does he say, why are you Mirandizing me? Why are you reading me my rights? I just did something great. Why am I here? He's booked. We see him go through all that process. Whenever he's booked into the jail. Right? Goes through the pictures. We saw the whole video of it. He never says, boy, why am I going to jail? I don't, people that do right things, that do the correct thing, don't get arrested. That doesn't happen to him. He never disputes it. He never talks about it, never objects, not one time. We know that Mark Becker has no problem asserting himself in the interview and asserting himself with the police. He's more than willing to talk to them. So that is not it. It's not that he's some meek and mild-mannered guy. Right? But he never once objects to anything that the police are doing that would all indicate that he's being arrested and doing something wrong. If what Mark Becker did, what he thought was right, he is behaving like somebody who did something wrong. Right? Correct? He's waiting to get arrested, holds the gun out the window, does all those things. Does all those things. He's acting like somebody who did something wrong. And by the way, the instructions also tell you we are not concerned with his moral judgments. This is a legally right or wrong. Did he know that he was that his actions were right and wrong as it relates to the acts with which he is accused? That's what the standard is. His actions in this case speak louder than words. From the moment that he left the weight room, by the way, he did leave the weight room. I'm not saying that he fled Butler County, but he did flee Parkersburg. He left. He didn't stick around, right? Somebody who was just did something right, I'm going to stay. I just did something great. I just killed the devil. Just knocked out Satan. He would stay. Instead, he leaves. Actually, there's some evidence that he really punched it when he left. We'll talk about that in a second. When he gets out to the Becker residence, to his house, he knows he's going to be arrested. He even makes the comment twice in his interview concerning knowing that he was going to be arrested, indicating that he was caught. We'll look at that here in just a second too. But you know what? Whenever you look at all this, look at his actions. His actions really do speak louder than words in this case. I should say this. The elements of insanity that we just looked at earlier, there is really an operative phrase that applies to both nature and quality of the acts and difference between right and wrong. And that is whether or not the defendant had the sufficient mental capacity to do those things. All right? In this case, in Mark Becker's case, he had the sufficient mental capacity to do a wealth of things. A lot of things that required complex thinking and planning. And we're going to look at those. And we're going to start back with some of Mark Becker's history. Mark Becker had the sufficient mental capacity to hold a job and to train other people. Apparently his boss at Old Chicago had enough confidence in him that he would let him train Mr. Cloverdance. So he had the sufficient mental capacity to hold a job and to train others in the job. He had the sufficient mental capacity to flee from Rogers' residence when the police arrived. Think about that situation that Mr. Rogers testified about. He described what Mark Becker was saying. We have no dispute with that, the whole baseball bat incident. But what happened when the sirens came blaring down the street in Cedar Falls? Who left? Mark Becker did. He took off. Well, we know he's in a state of some sort of, his mental illness is evident to Dwight Rogers. We don't, like I said, we don't need to dispute with that. But why do people run from the police? Why does that happen? Because they did something wrong and they know it. That's why they take off. If he was really in a state of mind where he didn't know the difference between right and wrong as it related to Dwight Rogers, he would have stayed and told the police, look what this guy's trying to do to me. Instead, he runs from the police and takes them on a high-speed chase. The only thing that stops him is a deer. Who knows where that chase would have ended? But the bottom line concerning the whole incident at Dwight Rogers' house is he knew what he was doing was wrong, so he took off. He ran from the police. He is able to have the mental capacity to convince his parents that he was locked out of his apartment when he was not. We know that Adam Taylor, on the day before the shooting, took Mark Becker home, let him in his apartment, he didn't have his keys, and then left him there for the evening. Mark Becker left the residence. At some point, he tells his mother, Joan, that he's locked out. Whether that was at Burger King or whether it was on the way home, nonetheless, he told her that she was locked out. He was not locked out. Well, why is any of that important? Why does that matter? It matters because Mark Becker is actively manipulating his parents. He wants to go home. He knows he's not supposed to. And even Joan knew that she wasn't supposed to contact him, but you know what? What is she supposed to do? If her son is telling her these things, I mean, leave him on the streets of Waterloo? I mean, that may have been what was going through her head. You know, and there should be no fault here with regard to, at least, you know, with picking up Mark laid at the feet of Joan or Dave Becker. I mean, really, Mark is the one who's responsible for this and for himself with what he did. But that's why the unlocked door is important. He is able to have the mental capacity to do those things. He wants to go home. He wants to get out to his house. He doesn't, for whatever reason, want to stay at his apartment. And the only way, and he knows this, right? He knows he's not supposed to contact his mom. Adam has told him that. Right? That's the only way he can make it happen. He has the mental capacity to come up with that. This is after he's let out of covenant. He's able to convince his parents to pick him up, take him home when he specifically was told not to get there. I get ahead of myself sometimes. He's also able to have this capacity to convince his parents that he's better than he'd been in a long time. His mother said that about him whenever she saw him. Quite frankly, I don't remember her exact testimony, but it was something to the effect that he was better than when he had seen him in a long time. And she was happy about that. He is able to have the mental capacity to make the decision to kill Ed Thomas. We know that from all of the evidence in the case. This is kind of encompassing statement, encompassing a lot of facts and evidence in this case. But he is able to make the decision to kill Ed Thomas. And by the way, we'll play a clip here in just a minute. He decided not to kill Thomas's family. It is in the interview to Chris Calloway, and we'll play that right now.
Were you going to hurt anybody else?
No, nobody else. Nobody but him. It crossed my mind to take his family when I was drinking coffee, but I decided it was the right way.
It crossed his mind to take his family. Who else would he have been talking about other than Ed Thomas's family? He immediately dismisses this. All right, so he is able to weigh in his mind who he wants to kill. He made the decision to kill Ed Thomas. He made the decision not to harm Ed Thomas's family. He made a plan to kill Coach Thomas. He had the mental capacity to do that. He formulates this plan to kill him. He's able to hide, back up to the plan for just a second. He's able to formulate this plan because whenever he tells Calloway in the interview, I woke up, I steadied myself by drinking coffee. He's made the decision at that point in time as to what he's going to do. So he's had time to think about it, and he even has more time to think about it. He's able to hide that fact from his father, his mother, and his brother. Right? This thing that is so right, supposedly, for Mark Becker, he is able to hide that from mom and dad. Okay? He has a sufficient mental capacity to do that. What else does he have a sufficient mental capacity to do? Remember what the testimony was in this case whenever Dave and Joan Becker left the house. They felt that Mark was okay to leave alone. They both had to go to work. Both are working adults, and they had to go to work. So they took the keys, I think, to the Luma is what the testimony was. Well, there was a spare key that was left in the house. Mark Becker had the sufficient mental capacity to find that key. He found it and he used it whenever he got in to the Lumina. He's able to have the sufficient mental capacity to do that, to break into the gun cabinet, right? To know where the guns are, to go find them, to take the gun, right? Find the gun that was in there. He has a sufficient mental capacity to do that, to load it. To load the gun. He has a sufficient mental capacity to load the gun. Carl Bessman testified in this case. And whenever he came down in front of you, he demonstrated for you how the revolver works and how it loads. And it takes some know-how to load the gun. I mean, it's not a real complicated thing, but it still takes some know-how to load it. He had to find the bullets, he had to load the gun, and he had to know how it worked. And he had to have a reason for doing that. Do you think Mark Becker knew that whenever you load guns into or load bullets into a gun that it wouldn't shoot, that he wouldn't know what the nature of a firearm is? Clearly, he does. Clearly he does, and he was able to do that. He practiced with the gun. Right? He goes outside, shoots it into the ground in the back, then he goes out into the front and shoots at the birdhouse. Right? He's able to have the capacity to do those things. He's able, this is important, this point. He's able to discern that he'd have to get close enough to Coach Thomas in order to kill him with the gun. All right? Whenever Mark talks about that in the interview, we've heard it in our first closing. He had to get close enough to him because he had missed from about 30 feet away. Okay, so think about that. Mark Becker gets the gun and loads it. He goes outside his house. He points the gun at a birdhouse and he misses twice. Okay, he's practicing. He's measuring up how he's going to make this happen. He then goes and examines the birdhouse to see if it's hit. And notices that it's not. And knows then that he's going to have to get close enough to him. What happened in this case? Did Mark Becker stand back at the door and aim and shoot at Coach Thomas? No. He already knew that when he walked in, when he poked his head in, he's going to have to walk across that room, go right up to him and get close to him because that's what happened. He'd already rehearsed it before. He also is able to reload the gun. Once his practicing is done, he's at least fired 3 rounds out of that revolver. He doesn't just willy-nilly put bullets back in the cylinder. He loads it fully, right? He puts all the bullets back in the gun to make sure that it's fully loaded when he goes on his mission to kill Ed Thomas. What else do we have? These 3 things. He's able to figure out where to go. Right? He's obviously familiar with the area since he's lived around here, lived around the Parkersburg area. He's able to drive a car. He's able to drive slowly enough that he's not going to get stopped by police or draw attention to himself when he goes to Applington and when he drives to Parkersburg. So as he's doing these things, as he's finding his way to Applington, finding his way to Parkersburg, and by the way, he explained why he went to Applington to look for Coach Thomas. He actually thought that's where he lived, which really wouldn't have been that unusual back last summer because of the tornado in Parkersburg. A lot of people, it was general knowledge that a lot of people from the tornado had been displaced and a lot of people had been displaced to Applington. Had to go temporarily live there. He is not looking at the beginning. Think about that. He's not looking for Coach Thomas at work necessarily. He's looking for where he thought he lived. So it's not that unusual for him to think or even make the mistake that he lived in Applington. So I would just submit to you, it's not unusual that he went there looking for him. Now, as he drives to Applington, he has the capability, the mental capacity to hide the gun in the car. Oops. He has the mental capacity to hide the gun in the car. What he also says about this is that he knew he had no driver's license. Remember, that's in there. That the statement to Callaway talks about Mark Becker having no driver's license and having the gun in the car. He's afraid he's going to get stopped. Well, why is that important? Well, look at that in relation to right and wrong. He doesn't want to get stopped. He doesn't want to get in trouble. If he's on this righteous mission that he claims to be on, why would he worry about that? Why would he worry about it? He asked Janice Stahl if Ed Thomas lived there, not the devil. He asked Buseman where to find Ed Thomas. He is looking for Ed Thomas, the person. He has a sufficient mental capacity to know those things whenever he's talking to Janice Stahl, whenever he's talking to Brian Buseman. If listening to the defense's closing argument, he's looking for Satan, right? And he's on this mission that's so right to him, or that he claims is right. But yet he tells Janice Stahl, Janice Stahl, and Brian Buseman that he's looking for Ed Thomas. Ed Thomas, the person. When talking to Buseman, he has the sufficient mental capacity to fabricate a reason that he's looking for him. For the tornado relief fund, that's why he says he wants to see Ed. He has a sufficient mental capacity to do that. He also has sufficient mental capacity to find Craig Kalkorff. He's given directions. This is what I mean by this. He's given directions essentially by Buseman that he's over in Applington. I believe Buseman said at the school. All right? Obviously, he has some background, the defendant does, in knowing where the schools are in Applington, and that's where he goes. He goes to a school. So he's able to find his way over to Parkersburg, which obviously, I mean, not that hard. Just straight down the highway, what is it, 5 miles or so to Parkersburg. But he's able to do it. He's able to find the school. He doesn't lose his train of thought. He doesn't get lost in some sort of other psychotic notion that something else is going on or anything like that. He stays on task, right? And he goes to the school. And he finds Craig Kalkorff. And he had taken the gun in before and talked to a woman in the school. He had the gun with him. He then leaves. And he takes the gun back out to the car. He has a sufficient mental capacity to hide the gun. This is hiding the gun a second time because he doesn't want Craig to see it on him. He doesn't want to get caught with the gun. Doesn't want to get in trouble. He's able to hide the gun before talking to Craig Kalkorff. And we have that clip from the interview.
And then did you go out to your car and put it in the car?
I put it in the car before I talked to Craig. Because I knew Craig might ask what was in his pocket.
Right? So he hid the gun before he went back in and talked to Craig. He's able to follow Craig's directions. He has the mental capacity, again, to stay on task. Craig gave him directions as to where Coach Thomas was at. He was at the bus garage, the weight room. And that is what he did. He followed the directions to location of Coach Thomas. He also, in talking to Craig Kalkorff, seemed normal, seemed conversational with him, and Craig even said that he was the best that he had seen him in quite some time. Craig knows Mark Becker. He knows him, and he's looking at him. And Mark's not having some fit of rage or insanity or any of those things that have been described about him before, or even that you saw on the video from June the 20th. None of that. He is calm, he is cool, and he is collected at this point in time. And also with Brian Buseman and Janice Stahl as well. He keeps the gun hidden. Once he gets down to the weight room, he's able to have the mental capacity to keep the gun hidden while he marks his target in the weight room. All right, he leaves, he calls it his piece or his tool. He leaves it back in the car, back in the Lumina, as he goes in and pokes his head in to see where his target is at. He has the capacity to do that, to keep it hidden, to stick to his plan, to stay on task. And he shoots him, and he walks in and he shoots him. And his mental capacity, he has a mental capacity to call him old man. He does not call him Satan. He does not call him a devil tyrant. If that is what Mark Becker was seeing, if that is literal in his mind, he refers to him as an old man whenever he kicks him. He doesn't kick him and say, F you devil, or F you devil tyrant, or F you Satan. He doesn't stand in there with his foot on the body of Coach Thomas and say, I just killed the devil. Everybody can be free. Instead, he calls him an old man and he leaves the scene. He has the mental capacity to avoid shooting at the students. If he is in the throes of some psychotic delusion and behavior, how is it that impairs his mental capacity to the point where he doesn't know the difference between right and wrong? How is it possible that he can make this decision? It's just simply not possible. We have a clip here in just a second. But whenever he goes in, he has the capacity to know that the kids need to be away. Now, there's one thing that he did whenever he walked in. Brandon Simpkins was standing next to Coach Thomas. He was our first witness. What did he do with Brandon Simpkins? He came in and he pointed the gun right at his head. Brandon thought he was going to die, but he didn't pull the trigger. Right? He didn't pull the trigger. Get away. Maybe that was the point of pointing the gun at him. But he has the capacity to do that. He has the capacity to make that decision. Let's hear that clip.
I think they all scattered.
Did you wait until everybody was away?
I made sure. I didn't want anything to ricochet.
Okay. And that was good?
They were a good 10 yards away, every direction.
Right? Chris Calloway even reaffirms to him, and that was good. And Mark doesn't disagree with him that that was a good thing to do. He also has a sufficient mental capacity to think about turning himself in. Okay? Why would somebody think about turning themselves in if they didn't do something wrong? That's what you would think that somebody would have in their mind when they make this statement. We have a clip concerning him turning himself in whenever he thought he was caught.
Did you think of doing anything else? I mean, did you think of leaving and going somewhere today other than your folks' home?
No way.
And you chose to keep the gun after leaving the school? Why is that?
I was going to turn myself in, I knew I was called. I don't know. It is in God's hands.
I thought about turning myself in. I knew I was caught. Jason Johnson just kind of beat Mark Becker to that punch because he met him at the house. But he thought about turning himself in because he knew he was caught. So why even make that statement? Why does that even cross his mind if what he did was right in his mind and he couldn't distinguish between right and wrong? He surrendered to Sheriff Johnson at his parents' house. Whenever he surrendered to Sheriff Johnson, he didn't, and he's holding it by the trigger guard, right? Just like this. Not in a threatening way. This is how he had it hanging out the window. This is how Jason Johnson described it. He knew that he was going to get arrested. He knew he was in trouble. He knew that there were legal consequences coming. He'd seen it before with the June 20th incident, right? He knew he was going to get arrested. He knew he was in trouble. Whenever he surrendered to Jason Johnson, It's another thing. Mark Becker also had the sufficient mental capacity to know that Ed Thomas was his teacher and his football coach. He even called him that in the interview. Again, not Satan, not a devil tyrant. And we have a clip of that comment.
How old are you?
24.
24? Okay. And was Ed your football coach?
He was my teacher and football coach.
What did he teach? I'm not from this area, so.
Taught me history.
If Mark Becker thought he was truly and literally the devil, why is he referring to him like this? He certainly has a sufficient mental capacity to know that Ed Thomas is a person and not literally Satan as it's been described. He makes multiple references to Thomas the person in his interview in the booking room. All those references, by the way, we've already been over that with all the witnesses in the case where he called him by name and called him a person or called him a man. Where he relives the shooting in the booking room, even when he is supposedly in the throes of this insanity that the defense wants you to believe. He still calls him Ed. He calls him Ed to Sheriff Johnson. He calls him Ed in the booking room. He doesn't call him Satan. He doesn't call him the devil. If that's what he literally saw and thought, why doesn't he call him that? He calls him, at least in this instance, by his name. He had the sufficient mental capacity to stay away from the weight room. This came from Dr. Taylor. But he had the sufficient mental capacity to stay away from the weight room if a policeman had been there. Why is this important? Why is that important? Why is it important to ask him? Because if he thought what he was doing was right, then it wouldn't matter if the policeman was there. Right? I mean, if you're driving along in a 35-mile-an-hour zone, all right, driving in your car, and it's 35 miles an hour, and you're tooling along at 60 miles an hour, and you see a police officer that's just sitting on the side of the road, what do? Hit your brakes, right? You stop because you're doing something wrong. If you're going 35, do you do anything? Or if you're going 30, you might look at the police officer, you might look at your speedometer, but hey, I'm okay, so I'm not gonna, you're gonna keep on going and doing what you're doing. That's my point. The same is true for Mark Becker. Whenever he saw, or whenever he was asked if he would have seen a policeman there, he would have gone the other direction. He wouldn't have gone in because he knew it was wrong. He has very organized and methodical thinking. This is another point. He has sufficient mental capacity to do this that kind of, it does encompass all the factors in this case. How he thinks this out, how he plans it, and how it's all organized really to the T as he goes through the morning whenever he commits the murder of Coach Thomas. Back up for just a second. So he had the sufficient mental capacity to do all of those things as it relates to his actions on June the 24th of 2009. Now, one of the issues that was brought up by the defense is the issue of motive as it relates to what Mark Becker was thinking, what his capacity was on the morning of June 24th of 2009. And I would just submit this to you, is that no motive is different from an unknown motive. All right? We do know the defendant was angry. He obviously was angry at Coach Thomas. Very much so. He's described as angry by everyone who was present at the shooting, those who could see him and describe his demeanor, and even the witnesses that were called by the defense that were on the outside of the weight room described him as angry. You can see him in, even though this doesn't relate to Ed Thomas on June the 20th, he's an angry guy whenever he's arrested by the police. And he is, at times, even whenever he's reliving that shooting, is angry, can be described as angry at that point in time on the booking tape that we've seen on June the 24th. He also says in his interview that he has deep-seated animosity. Okay? To put this in context, the whole interview is about what he's just done. Right? It's about Ed Thomas, it's about his involvement in the shooting of Ed Thomas, and he really volunteers this statement that we're going to hear now.
Did you go to the elementary school?
Yeah, I parked in front of the elementary preschool building.
Okay. Are you okay?
It's deep-seated animosity, that one.
Might that be a reason that he killed Ed Thomas, is that he had a deep-seated animosity? Yes. Might it be that he was angry at him? The answer is yes. Do we really know what the motive is in this case? Do we really know? We don't know for sure what the motive is in this case, but just because we don't know it doesn't mean he didn't commit the crime. There may be reasons that are unknown to us as to why the defendant killed Ed Thomas. But there is one thing that you need to take with you out of this courtroom, and that is we are not required to prove it. We're not required to prove a motive. It is not an element of murder in the first degree. It is not an element even of the insanity defense. Certainly, if we can bring evidence to any jury as to why something happened, which is what the motive question asks, is why did something happen, we give it to you. Well, the evidence in this case is Mark Becker was mad and angry at Ed Thomas, and that he had a deep-seated animosity towards Ed Thomas. But other than that, we are not required to prove motive, and we may never know what the true motive was in this case. I'm going to shift gears for just 1 second in talking about Mark Becker and his background that's been brought about, or been talked about a lot by the defense in this case. What are some other factors of Mark Becker's background that are important to your decision in this case? And there's one fairly significant one, and that is that the defendant turned away from resources that he had. All right? It's not like he is some homeless person that has no family and no support, or somebody, he comes from what is seemingly a decent family, right? I mean, certainly we have no reason to dispute that. But he has these resources. He had the capacity to ask for help from his parents if he wanted to that morning, if the voices are back, right? Adam Taylor was there for him. What are the other resources that he had? There are so many people that he could have asked for help on June 24th. Here's a list of them. There may be more. All right, his mom and dad, his brother, his friends, even Sheriff Johnson. Here's a guy who had helped him before, and not just arrested him and thrown him in a jail cell. He'd actually helped him before, gotten him to the hospital. That's what Sheriff Johnson testified to. And also with Adam Taylor and Dr. Campanini, Dr. Lassise, all these resources, all these people that he could have turned to, and Mark Becker made the choice to turn away from that. And as I had said in my opening statement in this case, took an expedient way to take care of his problem. Instead of turning to all of these resources that he had, what about Adam Taylor and Dr. Campanini from Covenant? They had seen Mark Becker right before the shooting occurred, or within 12 to 14 hours of the shooting, right? He had been examined, and he'd be able to be deemed to be released, all right? His hallucinations, everything had decreased. Mark Becker was fine, at least in their mind, whenever he left Covenant Hospital. Adam Taylor, who had been taking care of Mark, who was always there for him, the best, at least the best that he could. I know he has other clients that he has at Cedar Valley where he works, but he even asked Mark on their way home, how's your mental health? How are things going? Everything's good. Everything's fine. He even tried to get him stabilized back into his apartment, right? He'd been there for Mark, been there to help him. And he turned away from all of those resources. He turned from his support, and he concealed from all of them his plan to kill Ed Thomas on the morning of June 24th of 2009. Now, looking at all of those things, all right, all the things that we went through with regard to the defendant's mental capacity to do all those things, all the things that we talked about, how is it possible that he did not have the mental capacity then to know the nature and quality of his acts, or the difference, or the ability of the difference, or the ability to distinguish between right and wrong? If he had the mental capacity to do all of those things, oh, but yet when it comes to shooting Ed Thomas, he doesn't know what he's doing? You know, I mean, Mark Becker gives us this clear and concise story about what he did to kill Ed Thomas. It wasn't like he was saying, I walked outside of my house and I stuck my hand up into heaven and God himself gave me the gun and I was taken by angels to the weight room. I mean, nothing like that. His is a clear, organized, planned execution of Ed Thomas. So if he had the mental capacity to do all of those things, how is it possible that he has met his burden of proof in this case? The answer is that he simply has not met his burden of proof in this case. When it comes to right and wrong and nature and quality, in just a second, I want you to look at this list. Don't worry, I'm not going to read all the way through it. Okay? I'm not going to do that. But look at this. All the things that would indicate that he understood the nature and quality of his acts are on the left. All the things that we've talked about here, where he could distinguish between right and wrong, are on the right. All right? And I want to read you something from the instructions that the judge is going to give you. It's the definition of insanity as you look at these and study this list. And that is this: insane or insanity means such a diseased or deranged condition of the mind as to make a person either incapable of knowing or understanding the nature and quality of his acts, or incapable of distinguishing between right and wrong. He was capable of understanding all of this when it comes to the nature and quality of his acts and the rightness or wrongness of those acts. And I ask you again, how is it possible that Mark Becker has met his burden of proof as it relates to the insanity defense if he was able to do all of these things? Dr. Spodak and Dr. Taylor obviously disagree with the ultimate conclusions of Dr. Resnick and Dr. Rogers. They are well-qualified physicians with lots of experience in doing forensic type examinations, testified in many courts. You know what? They're every bit as qualified as Dr. Resnick. The doctors that we called simply confirm what common sense has already told you. All of those things that we just went through are very common sense facts in this case that show that the defendant understood the nature and quality of his acts and could distinguish between right and wrong. That's all they do. That's their evaluations, their assessment of the case. And you know what? This doesn't come down to a slugfest between Resnick and Rogers and Spodak and Taylor. All right? They're simply, all of them are one witness in a case that has an opinion based upon their expertise. Certainly something that you can consider. But you don't have to forfeit your own common sense when it comes to evaluating those facts. The judge will tell you that your own common sense can be applied in evaluating the facts and the evidence in this case, and that's what we would ask that you do. Simply put, the defendant has not met his burden of proof. Mark Becker is legally insane. If you get back in the jury room, this is his burden. It is by a preponderance of the evidence. If you get back there and you're just thinking, well, there's some things on Mark's side of the ledger and there's some things on the state's side of the ledger, we just don't really know, then he is legally sane. He has to prove it to you through the facts and the evidence in this case. You know what? And I would be foolish to stand up here and try to convince you that all of the facts in this case are on just our side and he has nothing. That would defeat what I just told you about applying your common sense in this case. Whenever you look at this case, though, as a whole, look at all of the things that were said and that were done by Mark Becker, you will find that he has not met his burden of proof that he is insane. You will find, in looking at all of this evidence, that Mark Becker has the sufficient mental capacity to understand the nature and quality of his acts. You will find, in this case, that Mark Becker has the sufficient mental capacity to distinguish between right and wrong. Mental illness, remember, does not equal insanity. You have to look at everything in this case. Look at all the facts and the circumstances. And when you do, this will be the conclusion. Mark Becker is legally sane, and he is guilty of the murder of Ed Thomas, murder in the first degree. As I said at the outset of this case, this is a case about choices. Mark Becker's choices. He calculated, he planned, he practiced, he executed, and later he explained them to us. But they are his choices and his alone that he made. They were organized, he was on task, and he got done what he intended to get done. Mark Becker made the choice to kill Ed Thomas. At the end of your instructions, the judge is going to tell you that it is your job to find the truth and to seek justice. Right? And to do justice. To seek the truth and to do justice. That's what your job is to do. To do justice. Justice in this case, when you apply the law to what Mark Becker did, clearly shows that he is not legally insane. It clearly shows that when you look at the elements of murder in the first degree, that he's guilty of murder in the first degree, and that he is not legally insane. Mark Becker walked into the weight room in Parkersburg on June 24th of 2009, and he gunned down Coach Thomas. He shot him 6 or 7 times. Did it in front of a lot of kids. You know what? Mark Becker is guilty of murder in the first degree, and that is the verdict that Mr. Prosser and I ask that you enter. Thank you.
Okay, Ms. Swanson, let your record reflect that the jury instructions are read to the jury at this time. You may be excused. I would like you to return to the courtroom when I get to instruction 34. I'll have Ms. Myrie get you at that time. Ms. Myrie is passing out copies to you. There should be a copy for seven copies, one for every pair of jurors. I know that you all can read, but part of my obligation as a trial judge in this case is to read the instructions to you. What you have in your hands, you have copies. The original set of instructions is bound. When you return your verdict, you will do so back at the end of these instructions. You will return one verdict. I will go through the verdict forms with you in just a couple moments after I go through the instructions with you. The trial information charges the defendant, Mark Daryl Becker, with the crime of murder in the first degree. The charge of murder in the first degree includes the lesser charges of murder in the second degree, attempted murder, willful injury, assault with intent to inflict serious injury, assault causing bodily injury, and assault. The defendant has entered a plea of not guilty to the charge contained in the trial information. Now you will note that there are bold headings at the beginning of each instruction. Those do not constitute part of the instruction. Those are simply my shorthand headings to give you an idea of what the instruction talks about and to help you get around and through the entire set of instructions. 1, the defendant has entered a plea of not guilty. The plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. The trial information is a document that formally charges the defendant with a crime and is merely the method by which the defendant is brought into court for trial. It is not evidence. The defendant is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charges, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. 4, the burden is on the state to prove the defendant guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case or from the lack or failure of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense, the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt, therefore, must be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it. However, proof beyond a reasonable doubt does not mean proof beyond all possible doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt and you should find the defendant guilty. But if, after a full and fair consideration of all the evidence in the case, or from the lack or failure of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt and you should find the defendant not guilty. You must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. You must consider all of the instructions together. No one instruction includes all of the applicable law. Nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. During the trial, you've been allowed to take notes. You may take these with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room and they will be destroyed. Evidence. You shall base your verdict only upon the evidence and these instructions. Evidence is testimony in person or by deposition, exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. Stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received into evidence are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers, objections, and rulings on objections, testimony I told you to disregard, anything you saw or heard about this case outside the courtroom. Statements and questions by law enforcement officers during interviews and conversations with the defendant are not evidence to be considered for their truth. The defendant's answers and responses to those questions and statements are evidence. In considering the evidence, you may make deductions and reach conclusions which reason and common sense lead you to make. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of one who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances indicating the defendant is either guilty or not guilty. The law makes no distinction between the weight you may give to either direct or circumstantial evidence. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Credibility. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, whether the testimony is reasonable and consistent with other evidence you believe, whether a witness has made inconsistent statements, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts, witness's interest in the trial, their motive, candor, bias, and prejudice. You have heard testimony from persons described as experts. Persons who will become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. In this case, the defendant has decided not to testify. The defendant is not required to testify, and no inference of guilt shall be drawn from that fact. The burden of proof remains upon the state to prove the guilt of the defendant. You've heard evidence claiming certain witnesses made statements before this trial while under oath which were inconsistent with what the witnesses said in this trial. If you find these statements were made and were inconsistent, then you may consider them as if they were made at this trial. decide whether to consider the earlier statements for any purpose and what weight to give to them. You've heard evidence claiming a witness or witnesses made statements before this trial while not under oath, which were inconsistent with what the witness said in this trial. Because the witness did not make the earlier statements under oath, you may use them only to help you decide if you believe the witness. Decide if the earlier statements were made and whether they were inconsistent with testimony given at trial. You may disregard all or any part of the testimony if you find the statements were made and they were inconsistent with the testimony given at trial, but you are not required to do so. Do not disregard the testimony if other evidence you believe supports it or if you believe it for any other reason. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act and he did it voluntarily, not by mistake or accident. You may, but are not required to, conclude a person intends the natural results of his acts. Knowledge. For the defendant to know something means he had a conscious awareness that he was doing the act. 18. The defendant cannot be convicted by a confession alone. There must be other evidence the defendant committed the crime. In determining the weight and believability of the confession, you should consider defendant's mental capacity and intelligence, defendant's mental and emotional state at the time it was made, whether it was knowingly and intelligently made, whether the defendant understood it, any other evidence relating to the confession. The offense of murder in the first degree, as charged in the trial information, has within it the offenses of murder in the second degree, attempted murder, willful injury, assault with intent to inflict serious injury, assault causing bodily injury, and assault. You will first consider whether the defendant is guilty of the offense of murder in the first degree. If you find that the defendant is guilty of this offense beyond a reasonable doubt, you will use form of verdict number 1. If you do not find the defendant is guilty of this offense, you will then proceed to determine whether he is guilty of the lesser included offense of murder in the second degree. If you find the defendant is guilty beyond a reasonable doubt of murder in the second degree, you will use form of verdict number 2. If you do not find the defendant guilty of this offense, you will then proceed to determine whether the defendant is guilty of attempted murder. If you find the defendant guilty beyond a reasonable doubt of attempted murder, you will use form of verdict number 3. If you do not find the defendant guilty of this offense, you will then proceed to determine whether he is guilty of willful injury. If you find the defendant is guilty beyond a reasonable doubt of willful injury, you will use form of verdict number 4. If you do not find the defendant guilty of this offense, you will then proceed to determine whether he is guilty of assault with intent to inflict serious injury. If you find the defendant is guilty beyond a reasonable doubt of assault with intent to inflict serious injury, you will use form of verdict number 5. If you do not find the defendant guilty of this offense, you will then proceed to determine whether he is guilty of assault causing bodily injury. If you find the defendant is guilty beyond a reasonable doubt of assault causing bodily injury, you will use form of verdict number 6. If you do not find the defendant guilty of this offense, you will then proceed to determine whether he is guilty of assault. If you find the defendant guilty beyond a reasonable doubt of assault, you will use form of verdict number 7. If you do not find the defendant guilty of this offense, you will use form of verdict number 8. The defendant claims he is not guilty by reason of insanity. You must first determine if the state has proved all of the elements of the crime charged or a lesser included offense beyond a reasonable doubt. If you find the defendant has proved all of the elements of the crime charged or a lesser included offense, then you must consider the issue of the defendant's sanity. If you find the defendant has proved the elements of his insanity defense, then you will use form of verdict number 9. If there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. 21. The law provides that a person commits murder in the first degree when that person willfully, deliberately, with premeditation, and with malice aforethought kills another person. The definitions of certain terms used in this and following instructions are as follows. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the facts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. It is sufficient if it exists any time before the killing. Malice aforethought may be inferred from the defendant's use of a dangerous weapon. Willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Specific intent means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when the act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to, conclude a person intends the natural result of his acts. A dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used in its designed manner, capable of inflicting death. It is also any sort of instrument or device which is actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used, is capable of inflicting death. Deliberation and premeditation need not exist for any particular length of time before the act. If a person has the opportunity to deliberate and uses a dangerous weapon against another, resulting in death, you may, but are not required to, infer that the weapon was used with malice, premeditation, and specific intent to kill. Now in the instructions, I move to the specific elements. The state must prove all of the following elements of murder in the first degree. 1, on or about the 24th day of June 2009, the defendant shot Ed Thomas. 2, Ed Thomas died as a result of being shot. 3, the defendant acted with malice aforethought. 4, the defendant acted willfully, deliberately, premeditatedly, and with this specific intent to kill Ed Thomas. If the state has proved all the elements, the defendant is guilty of murder in the first degree, and you will then consider the defense of insanity as explained in instruction numbers 34 and 35. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you will then consider the charge of second-degree murder as explained to you in instruction number 23. The state must prove all of the following elements of murder in the second degree. 1, on or about the 24th day of June 2009, the defendant shot Ed Thomas. 2, Ed Thomas died as a result of being shot. 3, the defendant acted with malice aforethought. If the state has proved all of the elements, the defendant is guilty of murder in the second degree, and you will then consider the defense of insanity as explained in instruction numbers 34 and 35. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will then consider the charge of attempted murder as explained in instruction number 26. Instruction 24. Murder in the second degree does not require a specific intent to kill another person. 25. Concerning element number 2 of instruction numbers 22 and 23, the wounds inflicted by the defendant resulted in the death of Ed Thomas if they caused or directly, I think it should be directly, counsel, is that correct?
Yes, Your Honor.
Yes.
And ladies and gentlemen, I've just corrected that, so if they caused or directly contributed to the death of Ed Thomas. If you want to, go ahead and make the change on your copy. (26) The state must prove all the following elements of attempt to commit murder. 1, on or about the 24th day of June 2009, the defendant shot Ed Thomas. 2, by his acts, the defendant expected to set in motion a force or chain of events which would cause or result in the death of Ed Thomas. 3, when the defendant acted, he specifically intended to cause the death of Ed Thomas. If the state has proved all of the elements, the defendant is guilty of attempt to commit murder, and you will then consider the defense of insanity as explained in instruction numbers 34 and 35. If the state has failed to prove any one of the elements, the defendant is not guilty of attempt to commit murder, and you will then consider the charge of willful injury as explained in instruction number 27. The state must prove all of the following elements of willful injury. 1, on or about the 24th day of June 2009, the defendant committed an assault on Ed Thomas. Assault is defined at instruction number 32. 2, the defendant specifically intended to cause a serious injury to Ed Thomas. 3, Ed Thomas sustained a serious injury. If the state has proved all of the elements, the defendant is guilty of willful injury, and you will then consider the defense of insanity as explained in instruction numbers 34 and 35. If the state has failed to prove any one of the elements, the defendant is not guilty of willful injury, and you will then consider the charge of assault with intent to inflict serious injury as explained in instruction number 28. The state must prove all the following elements of assault with intent to inflict serious injury. 1, on or about the 24th day of June 2009, the defendant intentionally assaulted Ed Thomas. Assault is defined for you at instruction number 32. 2, this was done with the specific intent to cause serious injury. If the state has proved both elements, the defendant is guilty of assault with intent to inflict serious injury, and you will then consider the defense of insanity as explained in instruction numbers 34 and 35. If the state has failed to prove both elements, the defendant is not guilty of assault with intent to inflict serious injury, and you will then consider the charge of assault causing bodily injury as explained in instruction number 30. 29 defines serious injury. A serious injury is a bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or extensive loss or impairment of the function of any bodily part or organ. The state must prove all of the following elements of assault causing bodily injury. 1, on or about the 24th day of June 2009, the defendant did an act which was meant to cause pain or injury to Ed Thomas. 2, the defendant had the apparent ability to do the act. 3, the defendant's act caused a bodily injury to Ed Thomas as defined in instruction number 31. If the state has proved all of the elements, the defendant is guilty of assault causing bodily injury, and you will then consider the defense of insanity as explained in instruction numbers 34 and 35. If the state has failed to prove any one of the elements, the defendant is not guilty of assault causing bodily injury, and you will then consider the charge of assault as explained in instruction numbers 32 and 33. 31 defines bodily injury. The term bodily injury means physical pain or any impairment of physical condition. 32. An assault is committed when a person does an act which is meant to cause pain or injury to another person when coupled with the apparent ability to do the act. Apparent ability means a reasonable person in the defendant's position would expect the act to be carried out under the existing facts and circumstances. The state must prove both of the following elements of the crime of assault. 1, on or about the 24th day of June 2009, the defendant did an act which was meant to cause pain or injury to Ed Thomas. 2, the defendant had the apparent ability to do the act. If the state has proved both of the elements, the defendant is guilty of assault, and you will then consider the defense of insanity as explained in instruction numbers 34 and 35. If the state has failed to prove either of the elements, the defendant is not guilty. And if you could have Ms. Swanson come back in, please. Thank you. 34, insanity defense. The defendant claims he is not criminally accountable for his conduct by reason of insanity. A person is presumed sane and responsible for his acts. Not every kind or degree of mental illness or mental disorder will excuse a criminal act. Insane or insanity means such a diseased or deranged condition of the mind as to make a person either incapable of knowing or understanding the nature and quality of his acts, or incapable of distinguishing right and wrong in relation to the acts. A person is sane if at the time he committed the criminal act, he had sufficient mental capacity to know and to understand the nature and quality of the act, and had sufficient mental capacity and reason to distinguish right from wrong as to the particular act. To know and understand the nature and quality of one's acts means a person is mentally aware of the particular acts being done and the ordinary and probable consequences of them. Concerning the mental capacity of the defendant to distinguish between right and wrong, you are not interested in his knowledge of moral judgments as such, or to the rightness or wrongness of things in general. Rather, you must determine the defendant's knowledge of wrongness so far as the acts charged are concerned. This means mental capacity to know the acts were wrong when he committed them. The defendant must prove by a preponderance of the evidence that he was insane at the time of the commission of the crime. Preponderance of the evidence is evidence that is more convincing than opposing evidence. Preponderance of the evidence does not depend upon the number of witnesses testifying on one side or the other. Insanity need not exist for any specific length of time. 35 elements of insanity defense. If the state has proved all of the elements of a crime, you should then determine if the defendant has proved he was insane. In order for the defendant to establish he was insane, he must prove by a preponderance of the evidence either of the following. At the time the crime was committed, the defendant did not have sufficient mental capacity to know and understand the nature and quality of the acts he is accused of, or at the time the crime was committed, the defendant did not have the mental capacity to tell the difference between right and wrong as to the acts he is accused of. If the defendant has failed to prove either of the elements by a preponderance of the evidence, then the defendant is guilty. Procedures on retiring to the jury room. When you begin your deliberations, you should select a foreman or forewoman. He or she shall see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express his or her views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. It is your duty as jurors to consult with one another and reach an agreement, if you can do so without compromising your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong. But do not change your opinion as to the weight or effect of the evidence just because it is the opinion of the other jurors or for the mere purpose of returning a verdict. Remember, you are not partisans or advocates, you are judges, judges of the facts. Your sole duty is to find the truth and do justice. I am giving you 9 verdict forms. You will complete only 1 verdict form. When you have agreed upon your verdict and the foreperson has signed the verdict form, please notify your court attendant, dated the 24th day of February. That completes the written instructions. If you then go to the next couple pages, you will see the forms of verdict, beginning with form of verdict number 1 through form of verdict number 9. You will return one of those verdicts. In a minute, you will begin deliberations, and first decision you'll have to make is what you'd like to have for lunch, and Ms. Myrie will make arrangements to have that taken in so that you can begin deliberations. I did want to talk to you about any communication between me and you as a group. I will be, as is my practice, I will be at the courthouse at all times while you are deliberating, and counsel will not be far away. Neither I nor counsel obviously will be in any form of communication with you. In my opinion, the jury instructions are complete, thorough, sufficient for you to reach your verdict. However, if you have any questions, let me tell you about the procedure that we must use in that regard. If you have a question, the question must be in writing and signed by your foreperson. Then you would give the question to your court attendant, Ms. Myrie, who would bring the question to me. Once I get the question, I would draft or formulate an answer, but before I gave you an answer, I would run it by counsel for the state and counsel for the defendant. I tell you that because from my experience, that does take a little time, and I would anticipate, because counsel will not be far away, that we'd be looking at 15 minutes to a half hour to get a response to you. In addition, there are some audios and videos in evidence, and if you would like any audio or video played back, like to see it again or hear it again, we do not have the equipment for you to do that in the jury room. It requires a computer to run either the audio disc or the video disc. So if you do want to listen to an audio or audio disc or video disc, again, put that in writing, give it to Ms. Myrie, and please specify what video you'd like to see and what audio you'd like to hear. And in addition, please tell me whether you'd like to hear the entire audio, the entire video, or part of it, and what part. And then we would have you come back into the courtroom and view it with the equipment that's set up here. Alternates. You are the two alternates. You will not go back at this time to begin deliberations with the jury. I mentioned to you at the outset that the operative word you could rely on to know that you're finished with jury service would be that you are discharged. I'm not discharging you at this time. So it has not happened during my 24 years as a trial judge, but if one of the jurors who is deliberating, one of the 12, say becomes ill and cannot continue with deliberations, then you may be called to deliberate with that group. You remember the admonition I've given you a number of times about not discussing the case with anyone else, not viewing any newspapers, not listening to TV, not listening to the radio, any newscasts. You are still under those admonitions. So you two are not discharged at this time. When the jury reaches a verdict, either I or Ms. Myrie will call you and tell you at that juncture that you are discharged. But until you get that telephone call, you are not discharged. So if anyone should attempt to talk to you about the case, be firm, be adamant. I'm not discharged. I cannot talk to you. Ms. Myrie? One other thing in my notes, it's been a long couple weeks for you all, and you've been excellent listeners and observers, and I really don't expect you to work into the evening. I'm anticipating giving you what I call separation instruction at about 5 p.m. That instruction would tell you that if you've not reached a verdict, to leave everything in the jury room, and you may go home at that time and return tomorrow at 9 o'clock a.m. So if you've not reached a verdict by 5 o'clock, you will get another instruction from me, either in writing, or you will come back into the jury room and I will talk to you about what to do and when you should come back. Do you solemnly swear or affirm that you will keep the jury together in your charge until they've agreed on a verdict or until I discharge them, unless I permit them to separate temporarily overnight, on weekends or holidays, or in emergencies? Further, that during their deliberations you will not allow any communications to be made to the jurors, except to ask them if they have agreed upon a verdict, unless I order otherwise. Further, that you will not communicate to any person the state of the jury deliberations or the verdict agreed upon before it is rendered. If you will, please answer. I will.
I will.
I'm going to have you taken back to the jury room at this time to begin deliberations. It will be just a couple moments. Well, maybe can you get the exhibits right now and take them back? So if you will go with Ms. Myrie, you will begin deliberations. The two alternates, when you go back, you can get your coat and leave the coats, leave the courthouse at this time, subject to the restrictions I just gave you. All rise, please. Okay, have a seat, please. So, Mr. Note from you, sir, indicating that you all would like to view the Chris Calloway CD, and you specify where the defendant states, quote, deep animosity. And we have both the video and the audio ready to go. And although it says view, Ms. Myrie inquired further, and you would like to also hear the audio. Is that correct, sir?
That's correct, sir.
Okay. We will start with the video. You've been given a transcript of the interview to look at. The video will begin at line 664 and end at line 679 on the next page.
What was that again?
664 to 679. Why don't you take a moment just to review those lines now, because you can't watch the video and read the transcript at the same time. Everybody ready for the video? Have you had a chance to review that? I don't see anybody indicated that you're not ready. The defense counsel will play the video for you, and the prosecution will play the audio for you. Mr. Jones, if you would make a brief record on where you're starting and...
Thank you, Your Honor. This is going to be played from Defendant's Exhibit B. The timestamp on the video is 9:39 a.m. and 43 seconds. I believe we've got it stopped at the end of line 662, so the next thing heard should be line 664 in the transcript. It may actually be 666. Agent Calloway and Mark kind of talked over each other at times during the interview, so I believe we're going to start at 664, and I will stop it after line 679.
Where do you probably you go to elementary school?
Honor. If I may.
Mr. Prosser.
The state's going to be playing the same segment of the interview, but from the audio transcription from Agent Calloway's personal recording device as opposed to the video recording device. The portion we're going to play is in Exhibit 60 and is reflected in Exhibit 61, starting from, I think, right about the middle of line 669 where it says you go to the elementary. It may be before that, but somewhere on that line, and then just through line 675.
I didn't plug it in.
You go to the elementary school? Okay. Are you okay?
Ms. Myrie? Okay. If you would collect the transcripts again, please, and escort the jury back to the jury room. Ladies and gentlemen of the jury, we're going to adjourn your deliberations for this afternoon. As I previously directed you, go ahead and separate now, return to your homes, and reconvene Monday morning at 10 o'clock a.m. in the jury room. You've heard some of these rules before. I'm going to go over them again. It is so important to maintain the integrity of the deliberative process. At the heart of that is that you make your decisions or reach your verdict solely in accordance with the evidence presented in this courtroom and in accordance with the instructions of law I have given you. You've heard some of these before. When you are outside the courtroom, do not let anyone tell you anything about the case or about anyone involved with it. If someone should attempt to talk to you about the case, please report it immediately. Ms. Myrie, do they have your, I would prefer that if that occurred, they called you.
I'll be right on it with them.
Thank you. And then you know how to get in touch with me. So if you would leave your number with the jurors before they go, please. Do not read any news stories or articles about the case or about anyone involved with it, or listen to any radio or television reports about the case or about anyone involved with it. Again, please avoid reading any newspapers or news journals at all. Avoid listening to any TV or radio newscasts. In addition, although I've not specifically mentioned it before, subsumed in this admonition is the idea that you should not be on a computer searching out any type of information which might appear relative to this case. In fact, we judges are working on a standard instruction to give jurors in this regard in future cases. Do not do any research or make any investigation about the case on your own. Do not talk with anyone else about the case or about anyone involved with it until the trial has ended and you have been discharged as jurors. Anyone else includes members of your family and your friends. You may tell them that you are a juror in a criminal case here at the courthouse. Don't tell them anything else about it until after you have reached a verdict and been discharged as jurors. So when I say don't talk with anyone about this case, I'm indicating that you obviously are not to disclose to anyone the state of your deliberations, not to disclose to anyone any discussions that have gone on in the jury room. You are not to disclose to anyone your individual opinion, if you have one at this juncture, as to what you believe your verdict might be. Absolutely no discussion with anyone else about the state of your deliberations. Do you have any questions for me regarding these instructions? Yeah, I think they're straightforward, direct, to the point, and at the risk of reiterating, I implore you not to talk to anyone about this case.
Judge,
Yeah.
did you read the answer to the jury question? Did they have a copy of that? Was that your intention, or I just didn't want, you didn't mention it, I just wanted to make sure the court, you didn't overlook it, so.
Oh, thank you, Mr. Brown. Ms. Myrie took the answer to their question into them before they came out into the courtroom.
I wasn't clear on that, thank you.
Yeah, you've all had a chance to review that, haven't you?
Correct.
Yeah, thank you. Everyone's saying yes. Okay, have some good weekends, and I will see you Monday morning at 10 o'clock a.m. Thank you.
All rise.
Iowa Rule of Criminal Procedure 2.22 subsection 5 provides that the jury agreeing on a verdict unanimously shall bring the verdict into court where it shall be read to them and inquiry made if it is their verdict. A party may then require a poll asking each juror if it is the juror's individual verdict. I tend to do the polling myself. You are the foreperson, sir?
Yes.
Has the jury reached a verdict?
Yes, we have, Your Honor.
Could you give the verdict to Ms. Myrie, please?
Yes.
Mr. Becker, could you please stand and face the jury? The jury has returned form of verdict number 1. We find the defendant guilty of murder in the first degree. Is this the jury's verdict, Mr.?
Yes, Your Honor.
Is the verdict unanimous?
Yes, Your Honor.
I'm going to ask you individually at this time whether that verdict is in fact your individual verdict, guilty of murder in the first degree. If it is, answer yes. If it is not, answer no. Any further record you'd like, Counsel, Mr. Brown?
No, Your Honor.
With the jury?
With the jury, no.
Ms. Flander?
No, Your Honor.
All right, at this time, ladies and gentlemen of the jury, I am discharging you. And Ms. Myrie, if you would call the alternates and let them know that they're discharged as well. I'm going to join you in a few minutes in the jury room for some debriefing, if you will. I need to take a few minutes with Mr. Becker in particular at this time, and then I will be back to visit with you briefly in the jury room. If you could escort the jury to the jury room, please. All rise, please. Have a seat, please. Mr. Becker, pursuant to Section 811.1 of the Code of Iowa, your bond is revoked. You are now held without bond pending sentencing. Sentencing is set for April 14th, 2010 at 10 o'clock a.m. in this courtroom. I remind you of the available post-trial motions which you may make, including a motion for new trial and a motion in arrest of judgment. Those motions must be made at least 45 days from today's date and not later than 5 days before the date set for the pronouncement of the judgment and sentence, April 14th. Mr. Becker, at this time you were given over to the custody of the Butler County Sheriff pending sentencing on April 14th, 2010. Sheriff?